Okay.
Oh, I see we're live on YouTube now.
No, I was trying, but I was actually trying. Now it says our browser doesn't recognize the formats available. So I don't know. I'm not going to worry about it. It usually works.
Well, according to us, I see it says live on YouTube.
Yes, sir.
Okay.
Look, I don't care if it's broadcast live on YouTube.
I don't really care either, but I meant to do it yesterday, and so I thought I'd do it right today. Oh, well, if we're live, we're live. All right.
He just wants us to provide entertainment to the world. That's it.
Well, I'm sure that we'll have a following of thousands.
Well, I mean, their alternative is to watch the Advanced Family Law Seminar.
Well, that's true. That's true. All right. Well, let's get started then. We'll go back on the record. And Mr. Clark, you may continue, please, with your cross-examination.
Thank you, Judge. Mr. STAEHLE, you realize that you're still under oath today?
Yes.
And the oath that you're under, that Judge Hennigan put you under, was the same oath that you took when you gave your deposition on May 29th in my office. You realize that?
Yes.
And you swore to tell the truth, correct?
Yes.
Now, I want to talk to you about credibility for a second. I asked you about the down payment on the house.
Yes.
Hey, you remember
Yes.
talking to me about that?
Yes.
And you told me that the only down payment you put in was from a loan from your dad, correct?
Correct.
And you told me on that day, under oath, that you put no separate property into the house, correct?
Correct.
All right, sir. And yesterday you swore under the same oath that you wanted a reimbursement of $20,000 because you got a gift from your parents. That's what you said, correct?
Correct.
Well, that's not true, is it?
How so?
Well, sir, you told me that you didn't put any separate property in your house at your deposition, right?
Separate property from me.
You said yesterday that your parents gave you $20,000 and that was separate property and you wanted it back, correct?
Yes.
And you didn't tell me that in your deposition. You said you put no separate property down on the house, correct?
Yes. It was a gift. In my mind, I had separated out.
Do you have your deposition with you that since we emailed it to you?
Yes.
All right. Would you please look at page 124, sir?
Okay. Okay. I'm there.
You there?
Yes.
Do you see on line 12, page 124, where I ask you, I said, now you didn't put any of your separate property as the down payment of the house, and your answer was?
Says correct.
And I said, instead, you borrowed money from your dad so you could fund your portion of the down payment, correct? And your answer was?
I borrowed the money from my dad.
I'm sorry, there's something going on.
You're kind of staticky.
Yeah, you're statically that time. We didn't get that last response.
Can you guys hear me all right now?
Now.
Yes, sir.
Okay. Okay. Mr. Clark, could you please repeat that question?
Yes, sir. I said on page 124, line 15, instead,
Okay.
you borrowed money from your dad so you could fund your portion of the down payment, correct? And your answer was?
Correct. I borrowed it from my dad.
And then the loan was $25,000, correct?
Incorrect. It was 20,004 on his IRS is what I saw, the gift from him. And then Sir, yes.
I'm talking about your deposition when you were under oath and I was asking you about the down payment. Would you look at page 124?
Okay.
I asked you about what you put down on the house and you said the money you put down on the house was loaned to you by your dad, correct?
So that's the loan portion.
Sir, is that the answer you gave in your deposition under oath?
Yes.
All right. Now, on Petitioner's Exhibit 21, you filled out an inventory and appraisement, correct?
Correct.
Now, even though you didn't sign it, it's the one you provided to us, correct?
I believe so. Correct. I don't
Yes,
have
sir.
the exhibit in front of me at the moment.
Look at it then. Find it, please. It's exhibit 21. Go to
I don't have an exhibit list.
Okay. Well, it's already been admitted into evidence, and I will tell you, and the judge and your lawyer can confirm this, that when you were asked about the separate estate of the parties, the only thing you listed was a piano, a dining room table, a server, an office desk, a cabinet, clothes, and tree. And you talked about those yesterday, right?
Mm-hmm.
Is that a yes?
Yes. Yes.
And then when we ask about your separate property reimbursement claim against the community, you said none, correct?
I believe.
And then when we ask about a separate property reimbursement against your wife's estate, you said none, correct?
I believe so. Yes.
All right. So you told me under oath and deposition, you didn't put any separate property into the house. And you told us twice in your inventory and appraisement, you didn't put any separate property in the house. Is that right?
Yes.
Okay. Now, you did not bring any evidence at all of this alleged $20,000 gift to court.
The IRS statement from my dad is not proof.
Sir, you have not introduced any IRS statement from anybody that shows this gift, correct?
I don't believe so. I gave that one to my lawyer.
Well, it's not on anything that's been admitted into evidence. So let me ask you this, and we can shorten some things up. You've brought no evidence of any $20,000 gift from your parents. And since you didn't tell me about it in your deposition, I'll make this offer to you, sir. We'll go ahead and acknowledge your $20,000 separate property claim if you also acknowledge your wife's separate property claims. It'll make
no.
You refuse to do that. Okay.
Yes.
This is not your first marriage, correct?
Correct.
This is not your wife's first marriage, correct?
Correct.
At the time you married her, you knew that she had a retirement account.
I knew of it. Yes.
Yes. At the time you married her, you knew she had money in the bank from her previous divorce.
I knew of it. Yes.
Yes. And you know that those two types of property are separate property, right?
Yes.
You, on the other hand, had no separate property of any kind when you got married to your wife, your current wife.
Correct.
Okay. And you still won't acknowledge that she had any separate property claims. Is that your position right now?
Correct, because I don't know the amounts.
Oh, you acknowledge that she has some claims, you just don't know the amounts. Is that your position?
Yeah, I had no access. We discussed this in the deposition. I have no access, so I have no way of knowing what those amounts were.
I'm being very specific with my language. You acknowledge that your wife has separate property claims. You just don't know how much they are.
Your Honor, I'm going to object to calling for a legal conclusion.
Well, that's not a legal fact, Judge.
Overruled.
And that's a correct statement of your position. Correct, Mr. Staley?
Correct.
Okay. A little bit about your background. I think you've only been able to keep 7 or 8 jobs since you got married. Is that right?
7, yes.
You've had 7 different jobs. And although you have a degree in engineering, you are not a licensed engineer. Is that right?
I'm not a professional engineer. That is,
and that means
a license that allows you to do like civil engineering, public works.
Well, sir, in your deposition, you told me you did not have a license.
And I said I do not, and I still don't.
Oh, okay. All right. So you don't have a license. And your engineering degree was a 4-year degree, correct?
Correct.
Okay. Your wife has only had 2 jobs during your marriage, correct?
Incorrect.
Okay. She's worked for the Department of Justice.
She's worked for Carswell Air Force Base. She worked for that for, I don't remember the time frame. Then she worked for, it was a hospital off of I-20 and Matlock in Arlington. I forget, I forget the name of that one. And then she also worked for Cook's Children's Hospital in Grapevine. And then she's at FCI right now in South Fort Worth at the moment.
Yes, sir. All right. Well, we'll go through that with her, but do you remember when I asked you about that in your deposition, you admitted she'd only had 2 jobs?
No, I said she had 4.
Okay. You have been fired from a job, correct?
Correct.
She has never been fired from a job, correct?
Correct.
And is it fair to say that your wife is frugal with her money?
I don't know how I would best go about answering that one. She's conservative.
Well,
We'll
yes,
say conservative.
right. Well, she hadn't lost $50,000 trading options of community property, has she?
No.
Okay. And it's my understanding, and we'll go through this spreadsheet here in a second, but for instance, you've now asked for both of the kids' educational savings accounts. You now today want both of those accounts, all 4 of them, correct?
No, I said I get 2 and she gets 2. I get the USAA 2.
Okay.
It's the South
All
Side.
right. The fact of the matter is you only put $50 in any of those accounts, correct? Once.
I don't recall the exact amounts.
Right. But you want the cash anyway, right? Do you think you are a good steward of cash?
Objection argumentative.
Do you think you handle cash well?
Objection argumentative.
You told me in your deposition that your trading could be described as insanity. Do you remember that?
I didn't use those exact words, but
Oh, well, let's see what you
I
did.
remember the discussion. The
Yes,
definition
sir.
of insanity is what I said.
Let's look at it. Because that was your definition that you offered, not mine, correct?
Yep.
Okay. Look at page 84 of your deposition, sir.
Okay. I'm there.
You're there? Okay.
Yes.
Okay, I'm sorry, page 85.
Right.
Yeah, the definition, I asked you if you got any criticisms of your trading on line 7, page 85. And your answer was, do I have any? You see that?
See that?
And what was your answer as to, do you have any criticism of your
The
trading?
definition of insanity.
And I asked you,
Sorry,
what did
sir, what
you,
was your answer? I'm sorry. Could you repeat your
Is
answer?
it cutting out again?
Yes, sir.
yeah.
I'm sorry about that. Okay.
So let me back up just a little bit. I'm
Sure.
I'm talking too
Mr. Clark.
fast.
You're cutting out some, sir, and you're cutting off Mr. Clark's question somewhat. If you allow him to finish the question and you answer, and then I'll ask him, let you finish your answer before he asks the next question. Our court reporter has a hard time writing it down if both of y'all are talking at the same time, so.
Yes, sir. And I'll try to do that too, Your Honor. I also think Zoom has some sort of buffer,
I think it does.
interrupts people. All right, we're back on page 85 of your deposition.
Correct.
If you had any criticisms of your trading, and
Correct.
you said, ask me if I had any, correct, on line 8.
Correct.
What was your definition of your trading in the options?
I said the definition of insanity.
And I asked you what you meant by that, and your answer was?
Doing the same thing over and over and expecting different results.
And then we moved down to page 85, line 19. And I ask you, you just defined your option trading as akin to the definition of insanity, didn't you? And your answer was?
Yes.
All right. So I'll go back. You're asking for all this cash in the property settlement. Sir, are you a good steward of cash?
Objection argumentative and relevance.
Overruled.
I believe I am a good steward of cash and I am getting better.
Well, sir, the statements, the new Schwab statements that you provided to us last night show that last month in your Schwab account, you lost $5,000. And is that your definition of getting better?
I can't control what the market does.
Okay. In any event, we know that you took $50,000 of Lockheed retirement and you gambled it away on options to where now the balance is $1,800, correct?
I'm sorry, could you say the final amount? I didn't hear that.
I believe it's 1,800, sir.
In the IRA, it was 1294. I don't have the document in front of me at the moment.
Okay, 1,294.
I believe so.
All right. So basically, from your retirement, you lost roughly 98% of your money, correct?
Correct.
All right. Now, your wife never had any access to your option trading account at Schwab, correct?
No.
Okay. That may have been a double negative. Did your wife ever have access to your Charles Schwab option trading account?
No.
All right. Do you remember in your deposition when I asked you for the password to that account?
Yes.
And you gave me the password, correct?
Yes.
And you knew that the reason we wanted the password was so we could check the balances of that community property account, correct?
I didn't know your rationale for it and what you were going to do with it. I just know that you wanted it.
Yes, sir. But you didn't give me all the passwords, did you?
For what?
Well, the Schwab account, we tried to get into it. And apparently, once somebody tries to log in, it sends a text to your phone for a confirmation code. Is that right?
The only reason that it did that is because it didn't recognize the computer you were logging in.
All right.
As a
So-
safety protocol on their side.
So
Not
even though
that
you gave us a password, you know that we couldn't get in to that account. It was still a secret account, correct?
That calls for speculation and argumentative.
I will allow Mr. Staley to answer if he knows.
So, Mr. Clark, could you repeat that question, please?
Yes, sir. Even though you gave us a password to that Schwab account position, you know that that account still was not available for inspection by your wife, correct?
No, I did not know.
Did not know. Did you get a text that said somebody was trying to log on to your account?
Yes. They alerted me.
Did you get curious about who was trying to do that?
No, because they had everything logged out. That is their security.
That account was secret to your wife, correct? And it still is today. She can't look at it.
Correct.
Okay. Now, was it before or after you filed for divorce that, let me back up a little bit. Did your wife, Pon, ever ask you for a verification code?
No.
Okay. And you're under oath. You realize that.
Mm-hmm.
And that's a yes.
Yes. Sorry.
Sir, if you'll answer yes or no, the court reporter has a hard time picking up uh-huhs and uh-uhs. So please just answer yes or no.
Sorry.
Was it before or after you filed for divorce that you opened up the Texas Trust account?
I believe it was just after. I'd have to go back and look at the statements to see the actual open date. I believe it was just after.
Okay. And what you did once you, and your wife has never had access to that account, correct?
Correct.
It's a secret account as far as she's concerned, correct?
It's one she doesn't have access to.
And that means it's secret from her, correct?
And that's how you want to define it?
Yes, sir. So you gave us a password to the Texas Trust account at your deposition, right?
Yes.
And just like the Schwab password, that one was not available to her to look at your Texas Trust account, right?
Correct.
Okay. So those two accounts have community property in them, correct?
Correct.
And you have chosen to not give her access to those secret accounts, even when I asked you about that under oath, correct?
Incorrect. I gave you those passwords at the deposition, and then my lawyer instructed me to change.
Actually, hold on, just don't talk about attorney-client privilege.
Oh, sorry.
All right, well, let's talk about that. You swore under oath that you would not change any passwords until after this trial. Do you recall that?
Yes.
Did you change any passwords, whether your lawyer told you to or not?
Yes.
Were the answers you gave yesterday to questions under oath as truthful as the answers you're giving today?
Yes.
All right, let's talk about that. Let me ask you something right quick. Why did you swear to me that you wouldn't change any passwords and you went ahead and did it anyway?
Objection argumentative, attorney.
Why did you do that?
Instruct the witness done.
Overruled.
Why did you do that, sir?
Because I was instructed for improper protocol.
Okay, here, what I don't want you to get into is any conversations you may have had with your attorney. I don't want to do anything that breach the attorney-client privilege that you have.
So just right quick, then we'll move on. Mr. STAEHLE, you will admit that the Schwab account and the secret Texas Trust account had community property in it, correct?
Yes.
And you will admit that those two accounts have always been secret as to your wife, correct?
Per your definition, yes.
Yes, sir. And then even as we sit here today, she doesn't have access to either of those accounts, correct?
Correct.
And even though you swore to me under oath that you would not change any password, you went ahead and did it, right?
Objection asked and answered.
Sustained.
Now, when you opened up your Texas Trust account around
Yes.
that you got filed for divorce, and I'm looking at Respondent's Exhibit 112, which has been admitted into evidence. You took out of the USAA community property account, you took roughly $10,900, correct?
I don't recall $10,000 being taken out.
Well, I think under oath, when you did you told me actually that you remember you told me you were populating your account?
I remember populating, I remember that, but I don't recall a $10,000 amount.
Okay, we're gonna look at that in just a second.
Sure.
In any event, you took a large sum of money from your community property account and you put it in that Texas Trust account, correct?
Objection.
Yes.
Those facts not in evidence and argumentative as to large sum of money.
Sustained. As
You took at least $7,900, right?
Yes.
Okay. And you didn't tell your wife you were doing that.
No.
And you ended up leaving her with the grand total of $245 in the bank account, correct?
In that one account.
Yes, sir. And you took several $1,000s over the next several months and put it in that Texas Trust account, correct?
What statements are you pulling that from?
Well, I'll look at that in a minute on the statements. Every single
Okay.
you got after you filed for divorce, you put in your Texas Trust account, right?
Every
Yes.
single what? I'm sorry, Mr. Clark.
Paycheck. I'm sorry, Ms. Hudson, paycheck.
Yes.
Okay. And I believe you put your bonus check in that account, correct?
Without the statements, I can't verify which one it went into.
Okay. You did receive a bonus in 2019, right?
As in 2019, yes.
Yes, sir. Have you received a bonus yet in 2020?
No.
Do you expect to receive one?
No.
Well, on one of the, I call it a wish list or property division, you said that you insisted on keeping your 2020 bonus. Do you recall that?
I recall saying I want to keep my bonus.
Right. You've already spent your 2019 bonus, correct?
Hmm.
That's a yes?
Yes, yes,
All right. And you said then after you spent your 2019 bonus, you wanted to keep your bonus. That's what you told us on your wish list.
correct.
Okay. Do you expect to get a bonus in 2020?
No,
Is it fair to say that trading options like you did with the community property retirement fund is very risky?
yes,
And you said you subscribed to some sort of newsletter that gave you the strategies for option trading, correct?
yes,
And you spent community property money on that newsletter, right?
yes,
And you still subscribe to that newsletter, correct?
yes.
So with you, that newsletter has a track record of losing 98% of the funds you invested. Is that right?
I wasn't subscribed to them the entire time.
So on your own, and after getting their advice, you lost 98% of the money, correct?
Yes, yes.
And your wife had no say at all about how you were using that community property money in that risky trading, did she?
No.
Okay.
Well, no, she had input because I showed her and I tried to get her involved into options as well.
Talk about that. You tried to get her to invest some of her separate property in your risky trading propositions, correct?
Well, I showed her the platforms that I was using and I had her start doing it as well. And
Yes,
then,
sir.
then
My
she,
question was very simple.
okay, yes.
You
She,
tried to get her to invest some of her separate property money in your risky trading scheme, correct?
I don't know.
Object to the, Your Honor, I'm going to object to the question. Then it calls for legal conclusion of him defining what is separate property or not separate property in the question.
I'll take that out, Judge.
I'll sustain the objection if you rephrase, please.
Yes, sir. You at one point, according to your testimony, you approached your wife and asked her to join you in this investing endeavor that was obviously a losing proposition, correct?
Yes,
And the reason you did that is you had lost all of your money and you wanted her to refund or to put more money in the pot, correct?
no, I wanted her to see if she was good. From what I saw in the trial, she was very good. I wanted to get her involved.
You wanted to get her involved in your losing proposition. Is that what you're
No,
telling me?
not in mine. I wanted her to have her account.
You still have your account and you're still subscribed to the newsletter, right?
Yes,
And the only reason you're not trading today is because of the temporary orders. Is that right?
yes,
Okay. So once you're divorced and you're out some temporary orders, you're going to start this option trading again, correct?
Objection, relevance.
Is that your intention?
I'll sustain the objection.
Well,
Fine.
Mr. STAEHLE, on your proposed property division, if you look at what you're asking the court to do, you're basically trying to get the court to give you all the cash that's in the community, correct?
yes,
All right. So do you intend to keep trading options after Judge Hennigan grants your divorce?
Objection, relevance.
Sustain.
Some of the cash you're asking, let me put it this way. Some of the cash you're asking for is dedicated to your kids' education.
mm-hmm.
Is that a yes?
Yes,
Okay. Let's talk about the fidelity, long position, short position, whatever you were talking about yesterday. Do you recall that? The fidelity stock?
I don't have any stock in Fidelity.
No, sir. You lost $43,000 in a Fidelity stock trade and the IRS came after you about some taxes that you owed, correct?
It's not Fidelity, it's Pfizer.
Pfizer, I thank you so much. Pfizer, you lost $43,000 in a Pfizer stock trade. Actually,
That is incorrect.
the amount, let me show, well, Respondents Exhibit 62.
I recall the statements and I also recall the IRS letter as well. But again, I don't have enough money, as you can see, to purchase $43,000 in the Pfizer stock. As I said yesterday, that was an option strategy. It was a vertical, either a put or a call spread. I don't recall which one. And you sell a short side and buy a long side to hedge your risk.
Sir, I'm referring to Respondents Exhibit 62. Do you have that in front of you?
No, I do not.
Would you find it, please?
I don't believe I have that one.
All right. Well, I'll tell you what it is. It's been admitted in the evidence.
No, it hasn't.
Respondents Exhibit 62.
No, sir, it has not.
Okay. All right. Well, let me ask you, and then I can get it proved up through my client. Do you recall receiving a notice letter from the Department of Treasury that said that the securities total reported to the IRS was $43,734?
Yes,
Okay. And that was done, the notice date was February 14th of 2011. Is that correct?
without the letter in front of me, I can't verify the date, but
Okay.
I recall-
Sound about right?
I recall the contents of the letter, yes.
Yes. And so it said then that you would owe an additional tax of $14,656. Do you recall?
Correct. Yes.
And roughly, that's in the spring of 2011. Okay, we'll get your wife to testify to it. So in response to getting the notice from the IRS based on your Pfizer stock activity, you asked your wife for some money, correct?
I don't remember the exact date that I asked her, but we had talked about that, yes.
Right. And you remember that on March 8th of 2011, she wrote a check to you for $30,000.
Correct.
Okay. And you know that that check came out of her separate property.
I can't.
It calls for legal conclusion.
I don't know if it's a legal conclusion asking if he knows something.
Well, I'll sustain the objection as to whether it was her separate property. If you want to ask him what account it came out of, something.
Do you know what account it came out of? The money.
No, I don't.
And the purpose of the money that was given to you was to pay or help pay that tax bill that you had, correct?
Incorrect.
Why did she give you $30,000?
Because we put it in the Charles Schwab brokerage account.
And you lost it, right?
Yes.
Okay, so now we know that rather than only losing $52,000, your sworn testimony is you've lost $82,000, except for the $1,200 you still have, correct?
Well, that went into the brokerage, not the IRA.
The $30,000?
Yes.
Okay. Do you have any written proof of that?
Of what? Where it went?
That a $30,000 check from your wife went into the brokerage account?
I'd have to pull a statement or see if they can get it. I don't know how long they keep their financial records. I believe the rule is 7 years and then they dispense with them.
What money where did you get the money to pay for your tax bill?
Well, I have a job.
Okay. So that would have been 5 months of your salary to pay your tax bill, correct?
Well, you're still assuming that the tax bill was $14,000 and it wasn't $14,000.
How much was it?
Without the documents, I couldn't tell you.
Could have been more, could have been less, right?
Again, I don't know what it was.
Okay. Um, let's see the photographs. What do you guys think? Let me, I'm just getting some more exhibits. Yeah. Do you have, Mr. Staley, in front of you, respondents exhibits 23 through 35, their photographs?
No, I do not.
Can you pull them up, please?
I don't have access to them.
Okay. Do you remember the pictures I showed you at your deposition of you and your girlfriend in various public places?
Yes.
Do you remember there was a picture of your black truck in a parking garage, which is exhibit 23?
Yes.
Okay. And you admitted that was your truck?
Yes.
Exhibit 24 was you and your girlfriend walking through the lobby of the Omni Hotel. Is that right?
Your Honor, I'm going to object to this as relevance. It's cumulative. We've already stipulated those were his photos. He's in there.
Well, I'm a little troubled, Your Honor, that he doesn't have access to the exhibits.
Well, let's deal first of all with Mr. Pfister's issues. I did think that y'all had stipulated the fact that he was involved with this Miss Doney.
We did.
And so what's the purpose of the questioning about the photographs?
Well, Your Honor, the purpose was to, I'll go about it this way. Yesterday, you testified that basically Pon was not a good mother, correct?
Objection argumentative, and that's not what he said. Mischaracterized his testimony.
I'll sustain the objection as to mischaracterization of evidence.
Yesterday, you said that you were concerned about Pon, your wife's disciplining of your kids, correct?
Correct.
You weren't concerned enough, but you left your kids with her while you were having your dalliances, didn't you?
Objection argumentative.
If you'll, I will overrule that objection. If you'll try to rephrase a little bit more.
Yes. While you were spending time pursuing your extramarital affair, you were leaving your kids with their mother, correct?
Correct.
All right. So you weren't worried enough about your kids or their mom's treatment to prevent any of your actions with your extramarital affair, were you?
Correct.
And in fact, before you even got separated, you weren't worried about the kids to the extent that you took your girlfriend to Kentucky for the weekend, for an extended weekend, correct?
Correct.
And you left the kids with your mom.
Correct.
She's no danger to those kids, is she?
Objection argumentative.
Do you believe she's a danger to those kids, sir?
A danger? No.
Yes, sir. All right. How old are your children now?
13 and 7.
Okay, it broke up just a little bit.
Okay.
Now, my understanding that you have filed a motion for Clarissa, who's your oldest child, your daughter, to confer with the judge in this case, is correct?
Yes.
Okay. Well, I'll go on record, Your Honor, that we wholly support that motion too. Is it fair to say that Clarissa and her mother have a close relationship?
No.
You mentioned yesterday an incident where you said that Clarissa and Ethan were left alone at the writing lessons for a while. Do you remember that?
Correct.
And that's the only instance that you know that they were left anywhere at the writing lessons. That's the only time, correct?
I have personal knowledge of, yes.
Yes. And you also know, because you showed up that day, that Clarissa's friend Alexis, who's the same age, was with your children, correct?
No, Alexis is 12, Clarissa is 13.
Okay, I'm sorry. But Alexis was with your daughter and son, correct?
Yes, my daughter was riding, my son was in the chair.
Right. And there were other adults and other people there at the writing lessons, correct?
Around, yes. There was
Yes.
an adult and one teacher.
And the fact of the matter is, sir, there are more than one instance, or there's at least one instance where you have taken your kids to writing lessons and you've left to run some errands and come back to pick them up, right?
Not Ethan, no. Clarissa, yes, but not
Yeah,
Ethan.
Clarissa. Okay. And Clarissa is perfectly capable of watching out for her brother being 13 years old, correct?
Not when she's riding.
Okay.
She's busy riding. That's why I will never leave Ethan alone and take him with me.
All right. You testified yesterday that you were somehow afraid that the children were being left at the marital home alone. Do you recall that testimony?
Correct.
Now, you don't have any personal knowledge of whether or not Pond has some neighbor ladies that look after the kids. Do you know about that?
Aside from Clarissa telling me, then the answer is no.
Where's our property division? Did you, I know that on the first exhibit 20, which is your proposed property division,
Correct.
you compile that chart yourself, correct?
Correct.
Okay. Now, Lisa Peterchuk from my office and Ms. Fitch, I think it's Jordan from your office, they talked last night and adjusted some numbers to get them more current. You make the exhibit that's the revised 20A. Did you do that yourself, or that came from your office?
I believe I did some of the work. It was a split effort.
I'm sorry, that got correctly.
Sorry. It was a split effort between myself and their office.
Okay. And you admitted earlier that basically in the property division, you want the judge to give you all of the community property cash, basically.
Correct.
And IRAs.
Not all the IRAs.
Okay, sir, you cut out a
Is
little
it?
bit on that one.
Okay.
Would you repeat your answer there, please?
Yes, sir.
Can you hear me now? Am I good?
I apologize, Mr. Thaley.
Is my signal coming through all right?
Yeah, it's fine now, but I didn't
Okay.
hear what your response to Mr. Clark's question was.
It was the cash accounts, some of the IRAs, but not all the IRAs.
It's all the cash accounts and just all the cash accounts you want the judge to give to you and one of the IRAs to your wife, correct?
Correct.
So you want the judge basically to give your wife assets that are not liquid. You know what liquid means?
Yes.
Okay. And you, of course, think that's fair.
Yes.
Let me refer you to Exhibit 140.
I don't have
Probably
access to
don't
that one.
have that one either.
Yeah.
Okay. Well, let's go through it right quickly.
Mr. Clark, is that your spreadsheet?
Yeah, you could call it that. I don't know if we can do it this way. This is the format.
Okay, that one I got. I was just sent that. have it up on
Okay.
my computer
And
now.
it's got a 140 on the bottom.
Hold on, let me double check.
It shows backwards in my screen. You have it, sir?
Yes, I have it.
Okay, great. Now, I think 140 has been admitted into evidence as a summary. So let's look at the proposal. On the proposal for the property division, we propose that you get the money in your Charles Schwab account. You would certainly agree with that, wouldn't you?
Yes.
And yesterday, our information was that it was 22,700. I think today or last night, the balance may be 17,000.
It was 17,781-ish.
Okay. Okay. But whatever it is, you would agree that if the judge gave that to you, that would be okay by you.
Yeah.
And then additionally, and we can make this go faster, our proposal would give you the Charles Schwab IRA number 1778, the TD Ameritrade, the Fidelity IRA number 1960, the Toyota Tacoma, that's your truck, right?
Yes, sir.
Valued at 6525. Your Texas Trust checking account, the one you opened
Yes, sir.
around the divorce.
How come you have my Tacoma on here twice?
I've just been informed that's a typo.
Oh, okay.
We're not going to give you two cars.
Oh, man.
Driving.
Can you paint the other one maroon?
Oh, for your Aggie heritage?
That's right.
Okay. All right. Yeah, that's a typo. So then the Texas Trust checking, that's your checking account that you opened right
Yes.
around the time you filed. Texas Trust Savings, I think that's at the same bank. Is that right?
Correct.
And then, I'm sorry, sir, but we're only going to award you one Tacoma.
Man.
Okay. All right. So as far as that part of the property division is concerned that we propose, I think you would say that's fair, correct?
Yes.
All right. Then our proposals, I'll go over with Pon about giving her some of the checking accounts. We'll go after that later. I just wanted to talk to you about that issue. Would you look down kind of towards the bottom? Do you see where there's a USAA rollover account?
Yes, I see it.
And for the record, the numbers end in 7273. You see that?
Yes.
Okay. I think the most current balance we have on that is $73,820.02.
Mm-hmm.
We are proposing to split that 50-50 with you. Do you think that's fair?
Well, really, we'd have a better snapshot of everything involved because it seems like there's quite a bit missing from the spreadsheet. Because your spreadsheet seems to be significantly smaller than the one that I developed. So are we missing accounts on here? Because my whole goal was to go through and go after more of the cash accounts and leave her with more of the IRAs, as is, I believe that would be a little bit easier to handle, would it not?
I don't answer questions, I ask questions, sir. My question is, as far as the USAA rollover, would you be splitting that by 50%? 50-50?
No.
You're not agreeable to that. I guess you want all of it?
No.
Okay. The gold and silver bars, those are little tiny bars that you can wear on a necklace, correct?
In theory, you could, but they're actually in because they are considered precious metal. If you take them out of the SA.
Sir, could you repeat that? You cut out for a second.
Oh, I'm sorry. So the gold and silver are in assays because they are precious metals. So taking them out of those assays ruins some of the value of it.
My point, sir, is it's not a brick of gold. It's
No, you're talking about half gram, 1 gram, 5 gram. There's smaller amounts that can be handheld, but they don't go on a brick.
right. So we're not talking about gold that's worth several $1,000s or anything like that, correct?
No, sir.
Okay. And then on exhibit 135, there's a photograph of 11 watches. Have you seen that photograph? Are those your watches, sir?
Yes.
Okay. What's the value? It looks like one of those watches is a Tag Heuer.
No, I don't have any tags.
What's the one that's got the silver band on it?
That would be the Seiko one that my mom gave me.
Okay. How much are these? Did you buy these watches while you were married, except the one your mom gave you?
Yes.
Okay. And are you willing to trade these watches? We give them to you and give your wife the gold bars, the tiny gold bars?
Tell you what, she can have the watches and I'll take the gold bars.
All right. We'll see about that. We'll ask her how she feels about that. All right. So your spreadsheet, of course, which is revised exhibit P20A, that makes no provisions for any property to
I'm
be.
sorry, Mr. Clark, could you repeat that?
Yes, I'm sorry, Ms. Hudson, I was looking sideways. Your proposed spreadsheet, which is now called revised exhibit 20A, makes no proposals at all for any confirmation of separate property for either you or your wife, correct?
Because I don't know what hers are.
Okay. And you were married in what year, sir?
2006.
And what day?
June 22nd.
Okay. Look at Respondents Exhibit 129.
I don't have that one.
Okay. Well, the judge has it and your lawyer has it. And it's in evidence. So the thrift savings plan, payment of a thrift savings plan would be your wife's property, correct?
No, because she continued to contribute to it throughout the marriage.
Sir, before you were married, you did not have a thrift savings plan, did you?
No, I did not.
Before you were married, your wife had a thrift savings plan, didn't she?
Yes, she did.
Respondents Exhibit 129 shows that before you were married, the balance in her account was $31,237.80. And you can't dispute that, can you?
No, because it's on a statement.
Okay. Then you also know that before you got married, your wife had accounts at Omni American Bank, which was then purchased by Southside Bank. Do you know that?
Yes.
Okay. I would refer you to Respondents Exhibit 130. Do you have that, sir?
No, I do not.
You don't have access to it at all?
No, sir.
Okay. Let me take you through kind of slowly. You do recognize that before you got married, your wife had money in Omni American Bank, correct?
I don't know. I can't.
You don't know one way or the other. All right. Respondents Exhibit 130 is a bank account from Omni American, and it says Pon Marsden. That was her name before she married you, correct?
Correct.
And it looks like in February of 2006, before you were married, she had a balance of $30,421 and some 30 some odd cents. Now you can't deny that, can you?
Nope, because it's on the statement.
Okay, so you will admit that that's the money she had before you were married.
And say the actual date on that statement.
The actual date on this statement, sir, is February 1st of 2006.
February 1st of 2000. Well, again, I mean, if you're saying June, then I don't know what she had. So you've got a 4-month discrepancy.
Well,
You're looking for the exact amount?
no. This is
I can't
this
verify
is,
that.
well, you could if you had Respondents Exhibit 130 in front of you, couldn't you?
Good, but I don't have it in front of me.
Okay. All right. What's the next one? Then let me, okay. Then all I want to do you have it Respondents Exhibit 131 or 132?
No, sir, I do not.
Okay. Well, the only these are already been admitted into evidence. The only purpose of this was that the balance recently of that account is roughly $16,895. And in another account, there's $27,485. You did tell me in your deposition, I believe, that your wife put some of her property for the down payment of the house. Is that right?
Yes.
And I think you acknowledged that in your deposition, but you told me that you weren't sure how much that was, correct?
I don't know the amount or where it came from, which account specifically.
The motor vehicle that she drives, I believe it's a Lexus, because it was involved in a wreck.
So what
Yeah, what car?
answer your question? Can you,
I'm sorry, you're cutting out again, Mr. STAEHLE.
sorry. Mr. Clark, I'm trying to figure out which one are you referring to?
Okay, I'm referring to what car did she have a RAV4 before you?
She did.
That
She
would
did.
be a Toyota RAV4.
That's correct.
And you acknowledge that she had that before you were married, so it was her separate property?
It was the RAV4, yes.
Yes. And I believe that RAV4 was involved in a motor vehicle accident.
That's correct.
And I think that your wife got a check for maybe $4,400 in property damage for the Toyota RAV4.
Correct.
Okay. And you would acknowledge that that would be her separate property?
Objection calls for a legal conclusion.
Sustain.
No, because I recall paying off her.
Sir, I sustain.
Oh, sorry. Sorry.
Next question, please.
Okay. So in any event, in your proposed property division, you've proposed that you keep your car and she keep her car, correct?
Correct.
You don't get two cars and she doesn't get two cars, right?
I'd love to have a maroon truck.
Well, maybe if the option trading turns around for you, you can get
Yeah.
a truck. All right. Did you ever, you've never banked at Southside Bank?
Yes, I have. Well, I've paid. I put the mortgage checks in. I will go and pay that.
Okay, that's who's carrying the note on your house?
Yes.
Okay. Let me shift gears a little bit with you. We'll talk some more property with your wife. The marital home where she and the kids have been living when they're on her week, that is within walking distance of Dunn Elementary, correct?
Correct.
And that's where Ethan goes.
Correct.
So if the judge allows Pond to keep the marital home, Ethan would be able to go to Dunn Elementary. Is that right?
Correct.
And you heard I believe it was the assistant principal from Dunn Elementary yesterday that said that her school had all the necessary facilities to properly educate somebody like Ethan. You heard that.
Correct.
And if the judge makes y'all sell the house, it basically uproots the children. Do you recognize that?
On her end.
Well, yes, sir. It takes Ethan out of the school and it uproots the.
No, no, my location is already in the Dunn Elementary School District.
It takes the children out of the home that they grew up in, correct?
Correct.
All right. And I think your position in this trial is that if the judge does not order the house to be sold, you would like to have whatever portion of equity he decides is yours, you would like to have that paid to you through a refinance on the house, correct?
Correct.
I think the way you put it yesterday was you wanted to make sure and get your name off the note.
Correct.
All right. And you've heard in this trial that depending on what the judge decides your portion of the equity in the house should be, that she is willing to refinance that. And that would be okay with you.
If she wants the house, she can have it. If she's willing to refinance, then she's approved.
Okay. But you realize the only thing you would get out of that would be whatever the judge decides your portion of the equity is. You know that.
Yes.
Okay. Judge, this might be a little early, but I can keep going, but I think if we took a very brief break, I can look through my notes and finish up really quick with this witness.
Up to you. If y'all need a break, we can take a break.
Okay.
All right. Let's take about a 10-minute break then, and we'll.
That'll shorten things up.
All right. Thank you. All right. We'll take 10 minutes. Hello? You hear me?
Yes, sir.
Yep.
Yes, sir.
Yes.
Y'all ready to get started again?
Yes, sir.
All right, Jennifer, you there?
Yes, sir.
All right, well, let's get started again. We'll go back on the record, and Mr. Clark, you may continue.
Thank you, Your Honor. Mr. Staley,
Yes.
you recognize that you're still under oath.
Yes, sir.
Okay, there's just a few little topics I want to clear up with you. I
Sure.
touched one of them earlier, but I'm not sure I got an answer. You told me in your deposition in May that the legal fees that were being paid to your current lawyer, Mr. Pfister, were gifts from your parents, correct?
Yes.
And you also told me that because they were gifts from your parents, there was no expectation that you had to repay them, correct?
Yes.
Okay. And that's true, isn't it?
Yes.
All right. Now, nobody's given any money to your wife to pay her legal fees. Do you understand?
Question calls for speculation.
Do you know whether anybody gave any money to your wife to pay for her legal fees?
I do not know.
Okay. And then finally, just to kind of sum up, in your deposition, when I asked you, you admitted that your wife, to your knowledge, has never cheated on you, correct?
That I know of. Correct.
Right. You admitted that your wife has never hid money from you, correct?
That I know of.
Well, you don't have any evidence that she did, do you?
No, I don't.
Okay. You don't have any evidence that she cheated on you, do you?
No, I don't.
Okay. And you also admitted finally that your wife, as far as you know, has never spent any money of community funds on anything other than her family, correct?
To my knowledge, correct.
Well, you don't have any evidence that she did otherwise, do you?
No, I don't.
Your Honor, I pass the witness. That's all I have right now.
Mr. Pfister, you have other questions?
Yes, sir. Briefly follow up. Just to jump, Mr.
Yes,
Staley,
sir.
I'd like to go back and address some of the things that came up on cross. For example, I believe on cross-examination, there was a question regarding whether or not you knew your wife had used the child's educational software. I can't remember what it was called, something or
iStation. iStation.
iStation. And you're concerned, he asked you whether or not you knew she hadn't used it. However, I believe you had reason to believe that she hadn't used it because she asked for the password, right?
That's correct.
And if she had been using it, she wouldn't have needed to ask for a password, would she?
That is correct.
Now, you currently live in that condominium, correct? And you've
Correct.
got a lease. Is your
Correct.
expectation, can you tell the judge, what is your expectation of what you would like to do for housing going forward post-trial?
Post-trial, I'd like to have the dust settle and start looking for a house in early spring. So we are ready to move out into a house next summer.
Okay. And you want to buy that in the Arlington ISD area, correct?
That's correct.
All right. Now, as I said, your current apartment is still in the Dunn Elementary area. So whether you're primary or not, Ethan, so it would still be zoned to go to Dunn, right?
Correct.
Now, Clarissa, would she end up changing schools?
Per my address, she is supposed to go to Bailey Junior High, I believe it is. However, when the Arlington ISD transfer opens up, I could just transfer her right back in. I believe the transfer date is in February of 2021 in the future.
So is it your intention that she would continue to stay in those schools?
She will stay at Young.
Okay. And then go to the high school that feeds to, right?
Correct.
All right. Now, Mr. Clark made a big deal about your accounts being, he said secret. And he gave his definition because your wife didn't have access to them. Using Mr. Clark's definition of secret, how many of Pon's accounts were secret to you?
A significant amount.
I'm sorry, sir. What was your answer?
A significant amount.
Thank you.
and essentially all of them, right?
Yes, sir.
You have access to any account that your name wasn't on.
No, sir.
And as the evidence is going to show, all these accounts are Pawn's, they're mostly in Pawn's name, right?
Yes, sir. Yes,
That's
sir.
where her paycheck goes. You don't know how much money she has.
No, sir.
Did Pawn make those accounts available to you so you can see what she was spending money on during the term of your marriage?
No, sir.
Okay, and getting back to, we're not trying to say that Pawn is a bad mom. I mean, in fact, you're offering a proposed visitation to 50-50, right?
Yes, sir.
And so, and as far as the children being left alone, you did have, while you don't have any hard evidence of that, you do have a basis of that to believe that children have been left alone numerous times,
Yes, sir.
right? And that's based on the statements of the children.
Yes, sir.
Okay. How many times have you had reason to believe that children have been left alone?
Quite a few. The exact number I can't put a figure to.
Okay. Well, I mean, Pawn goes to work early in the morning, right?
Yes, sir.
Do you know where the children are when she goes to work?
Ethan is at Primrose. I am aware of that one, and Clarissa is back at the house.
So she has to get herself to school every morning?
Yes, Clarissa has to walk to school every morning.
Now, again, since Mr. Clark brought it up, while you don't have any evidence, hard evidence that your wife's committed adultery, you do have some reason to believe she has, right?
Yes, sir. Yes, sir.
Your Honor, I object. This is leading.
I'll sustain the objection as to leading.
What is your basis for believing that she may have committed adultery?
She had a box of condoms, 2 boxes of condoms in her dresser drawer a week after I had filed for separation.
Okay.
That's when I found them.
Anything else?
She had receipts in there for different sexual items. And then she also had, I believe they're called pregnancy sponges in a box as well.
And just to give the court a little more background, how long had it been prior to you filing divorce that the two of you even shared a room?
She and I hadn't slept in the same room for over a year.
Okay. So you have reason to believe that those prophylactics and the things were
Objection
not
leading.
Saying as to leading.
Tell you what, I'll pass. Let's go through. We have our own exhibit. The revised, we went through last night and revised our numbers. And where's 20B? Your Honor, can I share the screen?
You have it on, Jennifer?
Yes, sir.
Yep,
Yes, sir, you
guys, I am armed and ready. Mr. Staley, I'm going to show you the revised Exhibit 20. This was a 20B.
Yes, sir. I see it.
And this is actually the proposal with the revised numbers from last night, right?
Correct.
And this was your current account, the Charles Swan account, based on this, that's the new number. And Ms. Petercheck, Pawn's other associate attorney, gave us some numbers, but we don't have verification for these numbers. We just took them what their numbers are, right? We haven't seen actual verification, but the number here, the 11.2, is 28.3, is 28.7, 11.9, this IRA. These are all numbers that we don't have hard numbers for, or we don't have the date, the corresponding backup, but we were verbally told this is what, correct?
Your Honor, I'm going to have to interject. I object to that question. I don't know whether Mr. Pfister has looked at the backups, but he hasn't.
No, we don't. And you can introduce them in evidence if you have them, because this is what was told to us last night, but the corresponding backup information has not. I'm using your numbers in this.
We will resend the backups to you over the lunch break.
All right. Now, this car, we now know the RAV4 predates the marriage, right?
Correct.
All right. So we're going to concede that the 4,400 is separate property, and so we'll have to strike that off the list. But otherwise, your proposal was not to just give her take everything. You did have one proposal here to give her, this is a $21,000 bank account, right?
Correct.
Which then gets you close to a 50-50 type split. Correct? All right, Your Honor, I'm going to, I guess as a summary of his testimony, offer 21B, because this has the more current numbers in it, with the exception of the 44. I guess now we're going to have to strike that.
Well, I think it's 20B, correct?
Yes, sir, 20B, my mistake.
All right, Mr. Clark, do you have any objection to the admission of Petition Exhibit 20B as a summary?
No, sir.
Petitioner's Exhibit 20B will be admitted as a summary.
With that, I'll pass the witness.
Clark?
You know, I didn't think we were going to have to go anywhere, but I just want to clear up one thing. You know, when I was asking you questions, you said you had no evidence at all that your wife has committed or has been involved in an extramarital affair, correct?
I said to my knowledge, I didn't know.
Right. And what you said to the judge after your lawyer asked you questions is you found out that she had condoms in a drawer after you had filed for divorce and when you had been sleeping with another woman for months, if not years, correct?
Correct.
And she has a medical background, correct?
Correct.
All right. She's being careful maybe about what you might have brought home, correct?
I don't know what she was thinking. I can
Okay,
only.
we'll ask her. That's all I had.
Okay.
Thank you. Mr. Pfister, any other questions?
No further questions.
All right, I just have one question of you, sir. Are you currently involved in any bankruptcy proceedings?
No.
All right, thank you. All right, call your next witness, please. Mr. Pfister.
Oh, I'm going to call Miss Pawn. Can you go get the printout? I'll call Pawn STAEHLE.
All right, go ahead, please.
Okay, ma'am. All right. Let me go. Can you first tell me, where do you work?
I work for the Department of Justice.
Okay.
I work for the Federal Bureau of Prison.
Right. And what do you do out there?
I am a medical technologist.
Turn her volume up. Your Honor, I'm having a little bit of difficulty hearing the witness.
Okay, you're speaking, your voice is very low, ma'am. If you could speak up a little bit or maybe turn up the volume, if you can, please.
Can you hear me now?
Oh, much better.
Much better.
Thank you very much.
No, she's fine.
All right, ma'am. The next question is, what hours do you work?
I work 6:45 to 3:15 p.m.
Now, did you tell me, do you remember taking your deposition, giving me your deposition
Yes,
back on February 11th, 2020?
yes,
Okay. Do you remember telling me in your deposition you worked at 6 a.m.?
yes,
Okay. Have you changed your hours?
yes.
Okay. And when did you change your hours?
During COVID,
Okay. Are you going to go back to being at 6 a.m. when this COVID ends, if it ever ends?
I never work at 6 p.m. Correction needed. I work at 6:30.
Do you remember telling me in your deposition you worked at 6?
The daycare does not open at 6.
If you'd be responsive to the question, please, ma'am.
No, I don't recall.
Okay. Well, actually, you did say 6:30. That was my bad. All right, so 6:30 is when you normally were working.
Yes,
All right. Now, let's talk about the proposed schedule. You heard Mr. STAEHLE is proposing that y'all maintain the week on, week off schedule, right?
yes,
Okay. Are you opposed? You're opposed to that.
yes,
Okay. You think the judge ought to give a standard possession order, right?
yes,
Okay. And why is that?
because it's not working.
Okay. Well, what's not working?
The 50-50.
Okay. How is it not working?
Because the children needs home base.
Children need a home base. Once again, ma'am, when did you decide that that was the reason that you needed to not have 50-50?
After the deposition that we had in December.
So after the deposition, and ma'am, I believe the deposition was in February, wasn't it?
Yes,
Okay. So after your deposition, then you decided, what do you mean by the children need a home base?
well, the home base give them bits, places where they know that they can be there. The place they grow up in. The neighborhood is, the kids can stay and play with the neighbors. I have people surrounding the neighbor that can watch and help. Also, since the COVID-19, everybody in the neighborhood get involved with me and help me with the children.
Okay. Now, in your deposition, you didn't tell me any of this, did you?
No,
In fact, I asked you what you thought about the 50-50, and then you tell me that you wanted to change it, but the only reason you gave me was because you wanted to spend more time with your children, right?
that is true too. Also, I spend quality time with them, one-on-one. We spend time together. We get to know each other. We do a lot of stuff that makes the kids feel at home and safe. And spending more time with, I get to know my kids. Clarissa is 13 years old. She needs her mom. I'm there for her when she has questions about the female. Anything that she needs, I'm there for her. Same thing with Ethan. I am patient with them. He needs mom one-on-one. Also, with his condition, with the ADHD and the asthma, I'm very patient with my kid. I have no distraction. I'm devoted to my kid. I do everything I can to help them.
So, ma'am, so why didn't you tell me any of this in your deposition?
Because I didn't understand your question
Well,
very well enough to understand, to answer them.
when I asked you what's going on, why don't you want temporary orders? What's wrong with the visitation schedule? You didn't understand my question to give me that same answer?
Well,
That's
back
what you're
then, I
telling
did
the
not
judge?
know it. Back then, I didn't have a clue that we can have options that was given during the temporary order.
What do you mean options?
Options to choose whether 50-50 or that there's standard code.
So are you telling me that in your deposition, you didn't realize that you could ask for a standard possession order?
Correct.
Okay. Well,
Also,
Objection, non-responsive.
Sustain.
I'll get to the next question now. Okay. Do you remember, just like your lawyer was asking, when you gave this deposition, you were under oath?
yes,
Okay. I'm going to show you your deposition. You recognize page 42 of your deposition? I said, what do you want to change? You said you wanted to change the schedule because you said primary. And I said, what do you want to change? You see here your answer, line 4, standard.
yes.
Keep going. I asked you, what do you mean by standard? Oh, 5th.
I said 1, 3rd, and 5th. That's what it meant on there.
Right. I thought you just told the judge 2 minutes ago that you didn't think you had standard as an option when you were taking your deposition.
That's deposition. I was thinking about the temporary order, doing the temporary order.
No, I was asking you about your deposition. I asked you, why didn't you give me those other examples? And you told the judge is because you didn't realize standard possession was one of your options during your deposition. And I'm saying is, you're talking about standard right here.
I am.
So why did you tell the judge that you didn't think standard was an option when you were doing your deposition?
I misunderstood your question. I didn't understand your question well.
Which question don't you understand? My question during the deposition or my questions now?
Both.
Both? Is that so? So do you understand my question here where I said, why do you want to go to standard? See line 13.
Okay, I want to spend time with my children. I
I
want
want
to
to
have
spend more time with my children.
Yes. I want them to have a home base. I am there with them when they're off school. I am there with them when they needed me. I am the one that taking care of them.
Objection, non-responsive.
Sustain.
Okay. I asked you, how are they doing? How have they been doing? You said they've been doing fine, right? I said,
right.
are they doing good in school? You said
Yes.
yes. I asked you, do they like the current schedule? You said they do like the current schedule. I even asked you, did you talk to Clarissa? She liked to change on Friday. She likes it. She liked to stay where it is. Right?
Not
you
right
talk-
now. Yes.
You
Yes,
talked,
Dan.
you talked to Clarissa right before the deposition and asked her about the schedule. So let me ask you, ma'am, are you telling the judge that somebody ought to have a standard possession order because that's better for the children than 50-50? Is that what you're telling the judge?
Can you clarify a little bit more?
Well, are you telling the judge that 50-50 is not good for the children?
Correct.
Okay. And that somebody ought to have a standard possession order, right?
Yes.
Okay. Well, what happens if it's Mr. Staley? Would it be better if Mr. Staley's primary and then you have a standard possession order? Would
Is
that be better?
two
Would that be
questions?
better
No.
for the children than doing 50-50?
No.
So if the judge chooses Mr. Staley to be primary, then you think the visitation ought to be 50-50, right?
No.
So what should the visitation be if Mr. Staley is primary?
Still standard.
So you should have a standard possession order then.
Standard.
I want to make sure you understand my question. So if the judge chooses that Mr. Staley ought to have primary, you think you should have a standard possession order?
No,
Okay, why not?
because I want to be parent primary.
Okay, I understand, but my question, ma'am, is if Mr. Staley's primary, should the judge give you a standard possession order or should he give you 50-50?
Standard.
He should give you a standard possession order instead of 50-50.
Yes,
Okay. All right. And you think you also, based on what your lawyer told me, oops, you want the judge to talk to Clarissa, right? Is that right?
I don't know.
Well, did you hear your lawyer?
Yes,
He was questioning.
yes,
Do you agree with your lawyer that Clarissa, the judge should talk to Clarissa?
yes,
Okay. All right. And if the judge does 50-50, you don't want to switch on Sundays. You want to switch on Fridays, right?
yes.
Okay. Why is Fridays better than Sunday?
Friday is when the kids come home, they come in the house, they're relaxed. I get to see how they're working. They're relaxing. We get to plan, sit down, and what we want to do for the week. We get back and talk about the whole week, what they did, that I was not there.
Okay. Well, do you talk to the kids when they're with their father?
I try to call them. I call
Okay.
them. I text them.
My answer, well, Clarissa has her own phone, right?
Yes,
So she can talk to you anytime she wants.
yes,
Okay. And didn't one of the things you complain about in your deposition is that she doesn't talk to you while she's with her father?
yes,
Okay. All right. But she talks to her father when she's with you, right?
yes,
Okay. Do you think you and Clarissa have a good relationship?
yes,
Okay. Have you always had a good relationship?
yes,
Okay. Have you had Clarissa tell you about her concerns with you?
yes,
Okay. Did she write you a letter?
yes.
Okay. Did you read it?
I read it.
Did that concern you?
Yes,
Okay. What did you do in response to that?
we had a talk and discussion.
Okay. Did you come to any agreements?
Yes,
Okay. What were your agreements?
we become a better mother-daughter relationship.
So how did you agree to become a better mother-daughter relationship?
We talk more.
Talk more?
Yes,
Do you hit less?
Objection,
No.
Your Honor. That assumes facts, not evidence. It's argumentative.
Well, no, it was that evidence from the father's testimony.
There was a, Mr. Staley did testify to that, so I'll overrule the objection.
So my
No.
question, ma'am, is do you hit less? Is that part of your agreement?
I do not hit.
If you'll rephrase that, I don't mind you asking her if she hits her, but not if you hit less.
Okay. Well, you heard Mr. Staley testify that you hit Clarissa, physically discipline her by hitting her.
I do not hit her.
Okay. And you're saying you've never hit her in the past.
No,
Okay. Have you talked to Clarissa about talking to the judge?
no,
No. Now, let's talk about a geographical restriction. You heard your lawyer earlier in the trial say, and on your requested relief, you're asking for Tarrant County, right?
yes,
Okay. And do you remember in your deposition, you said, I want Arlington ISD?
yes,
Okay. And I'm going to show you. Right here, question 9. I said, would you agree to Arlington ISD? Or question line 7, you said yes. Is that right? Was your answer then? Back in
Yes.
February of 2020?
Yes,
And I'm saying, are you proposing that the geographical restriction, Arlington ISD? Your answer was yes. And then I said, anything other than Arlington ISD? You said no. Right?
correct.
And then I even pointed out, even though your pleadings say otherwise, you still want to do that. So my question, ma'am, is why are today you're wanting Tarrant County instead of Arlington ISD?
Because I misunderstood your questions.
How could you misunderstand my question right there? What part of my, right here, what part of like line 9 and 10 did you not understand?
Because I was thinking about the kids' school.
So do you want to move the children out of Arlington?
If I have to,
No, not if you have to. Do you want to be able to?
I want to know.
Okay. So you want the children to go to school in Arlington, right?
Yes,
Okay. So tell me then, do you understand what domicile restriction means?
no,
No? So
no,
do you understand that means where the children have to live? And the parents obviously have to live in the same zone.
yes,
Do you think it would be better for your children if you and Mr. STAEHLE all live in Arlington ISD?
yes,
Okay.
no,
Do you think it would hurt the children if one of you lived further away so that the children had a longer commute to school?
I don't understand that questions.
Okay. So you agree that the judge should require the children and the parents to all live inside the Arlington Independent School District?
No,
Okay. Why do you not agree to that?
it makes a difference for the kids to travel.
What?
It makes the difference for the kids to travel.
Can you explain that to the judge and I?
I don't want the kids to travel. I want them to live close to the school.
So I get back to why should the judge not require everybody to live close together if your concern is that you don't want the children traveling far?
That is fine.
Okay, so that's fine now. Do you remember when you bought your house,
Yes,
steeplechase house? Do you remember putting $40,000 as down payment?
yes,
Okay. Do you remember that that money came from Mr. STAEHLE's father?
yes,
Okay. And you testified, you remember saying in your deposition, you remember that 20,000 of it was a gift from the father, right?
yes,
Okay. All right. Now, you heard your lawyer talk about how Mr. STAEHLE's accounts were secret to you because you didn't have access. Does he have access to your accounts?
yes,
He has he can write a check off your South Side and USA accounts?
no,
No. Can he go to the bank and withdraw money out of your accounts?
no.
Okay. So how does he have access to your accounts?
That is my separate account.
So my question, ma'am, is, does he have access to those accounts?
He's seen it all the time.
If you show it to him, right?
He see statement of the bank every month.
if you show it to him, right?
He have access to it. He checks the mail.
Okay,
He always know them.
all right. Well, let's go through some of your accounts. Can you pull, let me see which one I want. I forgot which one. Need. Ma'am, your retirement account that you had. What number is it? TSV 56. Exhibit 56. You're claiming your this retirement
Excuse me.
is all community property, right? Or separate property. You're claiming that's all is your separate property, right?
56, you said?
Yes. Do you have a copy of it in front of you?
I'm looking at it. Okay. Could you repeat the question?
You're claiming, if I see that you have a separate property interest in this account, according to your proposed property division, you're claiming that your lawyer introduced into evidence a statement that showed that 30,000, you had 30,000 in it when you got married, or 2 months before you got married, right?
Yes, 31,000.
Okay. And how much is in their account today?
Today,
It's just over 80, like 82,000.
I don't have that number, but I'm looking at the exhibit right now.
Well, if I go by your lawyer's proposed property, he says that 51,000 is community and 31,000 is separate. So if we add those two together, that's about $82,000. If I use your lawyer's numbers. Is that
Yeah,
right?
that would be correct.
All right. So ma'am, have you withdrawn money out of this account over the years?
No,
No? Let me show you what's been marked and introduced already as father's 56. See this? This was your 2018 statement, which was the one we had before trial, which showed your balance at that time at 67. And do you remember you put in about 11% of your salary every year, right?
yes,
Okay, and it's matched by the federal government, right?
the first year.
Hmm?
The first investment year.
Okay,
I believe first three, I have not checked, but I believe it was first, I don't remember what the,
all right. Well, here's the bottom line I wanted you to look at. The part I wanted you to look at is, see this part here, it says lifetime contributions. It says $105,000.
yeah, that's a lifetime. I don't have a lifetime.
Your lifetime contribution. This is how much you've contributed, your contributions for all your periods of service. So ma'am, my question is that if you've contributed $105,000 to this account for the entire time you worked for the federal government, why is your balance only $80,000, $82,000?
Well, it depends on the stock market. I have no control of it. I took a leave. Bureau in 2011 to 2013.
Okay. You didn't produce any of the other statements for this account, did you? Going back, you didn't produce your statements for 2007, 8, 9, 10, 11, any of those?
I don't understand your question.
Well, ma'am, the only statement that you're using to prove your separate property is that one statement your lawyer introduced in evidence, right?
Yes,
All right. Now, the same thing with some of these other accounts. You have, for example, you're claiming that you have a Southside savings account, right?
yes,
Okay. And that you want the whole thing to be your separate property.
yes, that's before the marriage of 2006.
Okay. Well, and you've been contributing to this account, haven't you?
Yes,
Right. And so, but you're claiming that this is all separate property, right?
I'm sorry, are you saying checking or saving?
Well, I'm going to go, let's take them one at a time. Your Southside savings account, 3590.
Okay,
Okay. The entire balance right now is $27,485, right?
yes,
And you've been putting money in that account over the last 15 years.
correction, no,
Okay. Well, didn't you tell me in your deposition how on these accounts that you've pulled money out to pay bills and then you put money back?
no,
No, you didn't tell me that?
no,
Okay. So are you telling me that you haven't pulled any money out of these accounts since you've been married?
no, not until last month I had to pay the bill.
Okay. And you haven't put any money in the accounts, right?
I never put the money in the account.
Okay. Well, don't the accounts earn interest?
Yes,
Okay. Is the interest left in those accounts?
the interest was pulled to pay the bill, legal fee last month.
Okay. What about your USA account? Once again, you introduced one statement, right? To show what that is.
Yes,
Okay. And you didn't produce any of the other statements between the date of marriage till today. You're saying you've never withdrawn from those, right?
yes,
Okay. I noticed that after the testimony from the Primrose teacher yesterday, did you send them a text last night?
yes,
Okay. And you're saying that from now on, you want to start you're going to start daily texting them, right?
as needed.
As needed. So why did you feel you had to send that text last night?
Because from what they're painting a picture of me, I didn't think that was a communication.
Well, before last night, you hadn't been sending them text and talking about your son, right?
Correct.
And you wanted them to give your son the ADHD medicine, right?
Replace.
You wanted them. Remember back she testified how you brought Ethan to school without giving him medication?
Yes,
Okay. So, and that you wanted them to give him the medication?
they've been getting medication.
Well, my question, ma'am, is why don't you give it to your son before you bring him to work, bring him to school?
Why? Because I want the medication to be on exact within the limit of Mr. Staley giving his dosage. It's better and stable that the medication is given in the same given time of the day.
It's not that it's just easier for them to do it.
Doesn't matter, they get paid for it.
Okay. Tell you what, I'll pass the witness.
Clark?
Yes, sir. I want the judge to get to know a little bit about you right quick, Hon. How old a woman are you?
I'm sorry.
How old are you?
On my birthday, I am 48 years old.
Okay. And tell the judge about your education. Do you have any degrees?
Yes, I do. I have 2 degrees.
What is your first degree?
I have a bachelor in biology.
And where did you get that from?
I got it from Southwestern Oklahoma State University in Weatherford, Oklahoma.
And what is your second degree?
I have a clinical laboratory science bachelor.
Bachelor's degree. And did you get that at the same school?
No, I got that at Monroe, Monroe, Louisiana.
All right. So how many years have you been in college getting your degrees?
About 7 years.
And then are you licensed by any state organization or any national organizations?
Yes,
What are your licenses?
I am licensed in medical technologist and also medical laboratory technician and also a non-technical X-ray.
Okay. My office is over in the medical district, so sometimes the sirens get a little bad.
I assume they were coming for you, sir.
Well, that's what I was trying to indicate. I hope they're not. Ms. Peterchuk, will you go lock the door?
She can take over.
So what does a medical technologist do, Ms. Staley?
I process laboratory blood testing. I collect blood and process and analyze and produce diagnostic results to the provider.
Who do you currently work for?
I work for the Department of Justice. I am working at the Bureau of Prison Division.
And how long have you had that job?
Altogether,
Yes, ma'am.
over 15 years.
Where else have you worked since you've been married?
I have worked for Baylor Hospital of Orthopedic
What were
in
you?
Arlington. And I have worked at Cook's Children's Hospital.
Okay. And what did you do at the 2 hospitals?
I do the same thing as a medical technologist for both facility.
So in your undergrad education and getting your 2 degrees and in your work for the federal government and at the 2 hospitals, is medical care important to you or not?
Yes.
And in obtaining those 2 degrees, I guess you had to study to get those degrees?
Yes, sir.
So are studies important to you?
Yes.
Now, was it difficult to listen to your husband testify yesterday about your activities regarding the children's academic studies?
Objection,
Yes.
Leading.
Very.
Sorry, Mr.
And what?
Objection, Leading.
Sustained.
Did Mr. Staley paint an accurate picture yesterday of
No.
your
Leading.
involvement with your kids' studies?
All right, I didn't hear you again, Mr. Pfister.
In objection, Leading.
Sustained.
Explain to the judge, before Mr. Staley was separated, what was your involvement with the kids as far as homework and studies?
I was 100% with Ethan. Mr. Staley was not involved with Ethan until January 2000. I
Objection not responsive on.
after
I'll sustain the objection if you listen carefully to the question, just answer the question.
Ms. Staley, we're going to talk about his involvement. I'm asking you right now about your involvement.
okay.
Explain to the court about your involvement in the kids' homework and studies.
I am involved with them 100%, no matter what it is, from homework, getting ready for work, for school, anything that they ask, I would be there for them 100%.
Well, so with Clarissa being the oldest child, what sort of subjects or topics did you help her or do you help her with?
I help her with science and whatever I can that she need help with.
What else?
Math, when I can do with her on algebra, and any question that statistic, math.
What about English or
English, we read, we read together and we try to work out together, but sometimes she does want to do her own thing.
okay. Where are you originally from?
I am from Laos originally.
And how long have you been here in the United States?
I came here in 1975 or 76.
Okay. What about Ethan? What do you do to help him with his studies?
For example, if he needs help with anything, we will sit down and do his homework when the teacher send homework, and we'll do spelling, reading, writing, making sentences, make sure he spelled correctly. We will write 3 times as needed, and he mess it up, we would write 4 or 5 times until he gets it.
All right. There was some testimony yesterday. I thought that your husband said maybe on one occasion you bought workbooks for the kids. First of all, is that a true statement?
I always bought the kids workbooks.
So I'm not real sure what a workbook is. Where do you buy them and what are they?
Workbook is, they have a book that's for pre-K, kindergarten, first grade, second grade, third grade. It's a workbook that you can work out. They have subject in it, 4 subjects: writing, reading, math. And
Are all those subjects in one workbook?
yes,
And have you always bought the workbooks for Clarissa as she's needed them?
yes, I bought it from Costco.
From Costco. And is Ethan old enough to use workbooks yet?
Yes, we work on it prior to his kindergarten.
Now, before Mr. Staley filed for divorce, was he involved with the kids and helping them with their workbooks?
No.
All right.
Hardly.
Pardon me?
No, but occasionally.
Okay. Generally, what would Mr. Staley be doing in the evenings while the kids were working on their studies with you?
He's watching TV.
Now, I believe that Ethan has been diagnosed with ADHD. Is that right?
Just in December 2019.
Yeah, less than a year ago, correct?
6, 7 months, 8 months ago.
Yes,
About
ma'am.
8 months.
And you don't disagree with that diagnosis now, do you?
I don't, but I do like to have more input on it.
Okay. And if I understood the testimony yesterday, the physician or the doctor who prescribed the medicine for Ethan, it's not something that has to be given every single day, correct?
Objection.
Correct.
Leading.
Sustain.
Is the medication that these are on, is it one, how often does it have to be given according to the prescription?
Per the doctor said when we had a conference, the doctor said that Ethan gonna have one dose of 4 ml, 1 a day, Monday through Friday during school time. And on the weekend, you don't have to administrate the dosage, but as needed if you wanted to.
that's just a judgment call for the parents, basically?
Yes.
Okay. What about summer?
I don't recall anything about summer.
Okay. Now, generally, talking about extracurricular activities, do you take the kids to extracurricular activities?
Yes, yes.
So tell the judge really briefly which activities you take the kids to.
I have signed up Ethan for swimming, for tennis, and both kids, Clarissa and Ethan, for tennis.
Do you play any of those sports?
Yes, I do.
What do you play?
I play tennis.
Okay. During your marriage to Mr. STAEHLE, did he ever ask you for money?
Mr. Staley have asked me for money.
Have you ever asked him for money?
No.
We had an exhibit. Do you remember getting a notice from the Internal Revenue Service?
No.
Okay. Do you remember writing your husband a check for $30,000?
Yes.
Okay. Let me get that exhibit. While I'm getting that exhibit, let me shift gears just a little bit. I've got it now. Do you have the exhibit book in front of you, Ms.
Yes,
Staley?
I do.
Would you look at what's been marked as respondents or R62?
What?
62.
Oh, 62, I'm sorry. Yes, I
Okay.
have it.
And have you ever seen that document before that's addressed to you and your husband?
No.
So did your husband ever tell you about the notice from the IRS?
No.
Objection, maybe. Okay,
Overruled.
actually, that's fine. I'll take the answer.
Then look at what's been marked as R63.
Sorry, you're my caddy.
Have it.
All right. What is R63? It's already been admitted into evidence.
It's a check, copy of a check
Who wrote?
I wrote.
And it's already in evidence. It's for $30,000. What on the memo line? There's a number there. What does that number signify?
Mr. Staley.
Your Honor, the check was not admitted in evidence.
Oh, I'm sorry. We did so many. So tell me what R63 is.
R63 is a copy of my written check.
Okay. And is it just the front or is it the front and back?
Front and back.
Okay. And this is a check that you produced in discovery, correct?
Yes.
And is anything changed on this copy? Is it a true and correct copy of your check?
Nothing changed.
Okay. Your Honor, I'd ask that Respondents Exhibit 63 be admitted into evidence.
Objections?
No objection.
Response Exhibit 63 is admitted.
All right. Then real quickly, Ms. Staley, the check is made out to your husband for $30,000. Is that correct?
Yes.
And there's a number, the memo section of the check by the word for, F-O-R. What is
Yes,
that
sir.
number? What does that signify?
An account.
And which account is that?
That's a joint account.
From where?
USAA.
Why did Mr. Staley want you to write him a check?
He stated he wants to invest
Invest in what?
stock market.
Was any of this money to be used to pay the IRS debt?
No, I do not know of.
Okay. Let me switch gears just a little bit. I should have done this earlier. Look at the very front part of your exhibits. I want you to look at exhibits 3 through exhibit 7. You have those yet?
Yes,
Okay. Just right quick. These are already in evidence, but what is the picture? What is exhibit 3
pictures
of who?
of myself, my son, and my daughter.
And what is exhibit 4?
Picture,
Of who?
myself and my daughter.
Is Clarissa still in braces?
Yes,
Okay. And exhibit 5 is who?
myself. I mean, it's a photo.
Pardon me? Yeah, but who's in it? These are already in evidence.
Myself and my son.
Okay. And then exhibit 6. Who is that in the picture?
A photo of my
Who?
son.
All right. And then finally, exhibit 7. Tell me who's in that picture.
It's a picture of myself and Ethan's birthday.
When was that taken?
A week after his birthday on the weekend.
How long?
I'm sorry?
That's okay. All right. So would you characterize your relationship with both your kids to be close?
Yes,
Where's the second? Let me see. Mr. Pfister, did we agree that that her car is a separate property? I think I heard you say that.
I'd agreed that that RAV4 was her separate property.
Okay, then I don't need this exhibit. Okay, then that saves us a little time. Ms. Staley, would you look at Respondent's Exhibit 129?
yes.
Let me let everybody get quick.
I haven't.
Yes, okay. So what is it, Respondent's Exhibit 129?
It's a copy of my TSP.
And the Thrift Savings Plan, or the TSP, is that through the federal government?
Sorry, Mr. Clark, could you repeat that?
Yes, ma'am. I'm sorry, Ms. Hudson. The TSP, or the Thrift Savings Plan, is that through the federal government?
Yes,
And what is the date of Respondent's Exhibit 129?
the date stated 06/21/2006.
Is that before you got married?
Yes,
And what is the balance of your thrift savings plan before you got married?
31,237.80.
Okay. Your Honor, I believe that's already been admitted into evidence. Let me ask you, Ms. Staley, to look at Exhibit 130.
Yes,
Can you tell us what that is?
it's a copy of my bank statement.
And when is it dated?
February 28, 2006.
Did you have any difficulty since we were looking all the way back to 2006, did you have any difficulty getting these statements from the bank?
Yes,
Okay. And so in February of 2006, which was before you were married, what was your balance in your Omni American account?
I have two. There's a saving and a checking.
Okay, the one that we're looking at now is checking, correct?
Correct.
Well, the both of
Both.
them are on this one. Okay.
Yes.
So what is your balance in your checking account?
My checking was $18,456.90 something.
And that's towards the top part of Respondents Exhibit 130, correct?
Correct.
And then you also had a checking, a savings account.
Yes.
What was the balance in February of 2006 before you were married?
$30,421.35.
Okay. Are you asking the court to confirm this as your separate property?
Yes.
Okay. Now, I believe that Southside Bank bought Omnibank. Is that right?
Yes.
Okay. So your accounts that were previously with Omnibank, they just moved to Southside Bank, and I think they kept the same numbers. Is that right?
Objection, leading.
Yes.
Did when
I'll answer that question.
when the bank changed from, or when Southside bought Omni, did any of your account numbers change?
Objection, leading.
No.
I'm going to overrule that objection. Just move that on, please.
Respondents Exhibit 133, please.
Have it.
All right, and it's already been admitted by agreement. What is Respondents Exhibit 133?
It's a copy of USAA Bank saving.
And is the account number the same as this account number ends in 6844, is that right? 6884.
Yes.
Okay. And this is dated in January of 04, is that correct?
Yes.
And what is the balance in this account before you got married?
$32,241.34.
Now, do you know what where's the current balance? Where is the document? Do you know what the current balance is in this savings account?
On the exhibit 40, I have $11,220.
Okay, so it's my understanding that even though you had $32,000 in this account before you got married, the current balance is only $11,200. Is that right?
Yes.
Are you asking to have the judge confirm that $11,200 as your separate property?
Yes.
You look at Respondents Exhibit 138. Do you
Yes,
see that? Now, this is actually a spreadsheet that you prepared. Is that correct?
Yes.
I want you just to explain to the judge and Mr. Pfister and Mr. Staley. When you look at the second box, which is in the middle, there is a account balance. Well, tell us what those numbers mean. In the year 2006, on the account ending in 6696, what is the balance?
As of on the spreadsheet, is 28,000
No, ma'am, that's 2020. I want to know what it was in 2006.
2006, it was 13,795.17 cents.
Okay. Did you put in or take out any money from that account?
No,
Well, just rather than go, tell us what this spreadsheet represents.
this spreadsheet represent the amount of money I had prior to marriage, and they have accumulate and make interest, and they have consolidated by the agent, the financial planner to reinvest.
Okay. So from this chart, as we look at it, what were your balances before you got married? Point those out to us.
Um,
Ron, I'm going to object to testifying about a document, not in evidence. If you've got direct knowledge of those numbers, you can, but.
Okay. All right, not necessarily the documents. Did you have any other accounts where you had,
I'll sustain the objection for the record. I'm sorry. I was in your.
I'm sorry, yeah, I jumped the gun, Judge. Other than what we've already talked about, did you have any other monies before you got married? Any other funds?
yes, it's all listed on this document that I have all my account.
And look at Exhibit 140, which is a summary.
Oh, 140, okay, never mind.
All right.
I
So,
see it.
yes, and under the column of wife separate property, are you asking the judge to take those amounts and confirm them as your separate property?
Yes,
Okay. Now, now look at Exhibit 140, which is our proposed property division. I asked your husband about this a little bit, but the first 1, 2, 3, 4, 5, 6, the first 7 items you would propose to the judge to give to Mr. Staley, correct?
yes.
Except there's a typographical error that he picked up, which is an extra car. we
We don't have an extra car.
don't have extra cars. Okay. But
Sorry.
that's what you would propose to give to Mr. Staley, correct?
Yes, no maroon car.
Okay. No maroon car yet, correct? All right. And then on the column on the right side of Respondents Exhibit 140, you're asking the judge to award that amount of money. Is that to you, correct?
Yes,
All right. And those are basically, you're asking for your Southside Bank accounts, and you're asking the judge to have you be the custodian of your children's savings account, correct?
yes.
Why are you asking the judge to give you custody or be the custodian of both children's savings accounts rather than just one?
Just I.
Why are you asking that? Why are you proposing that?
Because I'm the one that put the money in the account for them.
Okay. Did Mr. Staley put any money in the savings accounts for the kids?
No, I recall only maybe less than $100.
Okay. So the entire amount of the money in the kids' savings accounts, other than maybe $100, you contributed, is that right?
Yes,
Okay, then move down to on Exhibit 140, where it talks about the Department of Justice TSP retirement. Are you asking that the judge award all of that to you? The
I'm
50,
sorry, on which one?
the Department of Justice TSP retirement, the 51,000?
Yes,
Okay. And then on the USA rollover, you're proposing that the judge split that half and half, correct?
yes,
And then we get to the house. Do you agree with the appraiser's value of the house when he came out the second time?
yes,
Okay. And the house does need the foundation repair and the irrigation repair that the appraiser considered, correct?
yes,
All right. And in your proposal, you would like to keep the house, is that right?
yes,
And you understand that if the judge likes, or if the judge allows you to stay in the house with your kid, that, and if he awards any equity to your husband, that you would probably have to finance the house rather than cash out any other accounts to achieve that and give your husband some money. You understand that?
yes,
Are you willing to do that?
yes,
Okay. And not to get real detailed, but do you believe that you have the financial ability and credit rating and all that kind of stuff to have that happen?
yes,
Okay. And so in the proposed split of the equity, you're proposing that the judge award $20,000 to Mr. Staley and $72,000 to you. Is that right?
yes.
Okay. Now, did you have any, when Mr. Staley was engaging in his option trading, did you know that he was losing that kind of money?
No, I was not aware.
In the entire time that you were married to Mr. Staley, did you know that he had lost all of the retirement that he had earned during the
No.
marriage?
No, I do not know.
Okay. Did you ever spend any money on anything other than your family while you were married?
No,
Is it fair to say that you're pretty frugal? It looks like you've been able to save money and sock it away in retirement.
yes,
Have you ever asked Mr. Staley for any money?
no,
Has he ever asked you for any money?
yes.
What occasions would it be where he would ask you for money?
The first occasion would be that $30,000 for investment. The second occasion is when I had to pay his credit card chase bill in 2000.
How much was that?
Over $5,000
And when did you have to pay his credit card bill?
on the month that he asked.
Yeah, but what year was that? When?
I believe it's 2016.
And then did you pay off more than one of his credit cards?
Yes, the second one was another bill of over $5,000 in 2017.
Why were you paying off his credit cards?
He stated that he don't have any money to pay off
And what funds did you use to pay off his credit cards?
on my account.
Which account would that be?
That would be my checking account, my separate checking account,
Was that at Southside Bank?
Southside Bank.
Oh, so one other thing I want you to look at. Look at Exhibit 108. Do you see it?
Yes,
Is this, it's in evidence. Is this y'all's joint account that was at USAA?
yes.
If you look at 108, what were the deposits made into the account? Or what was the balance in May of 2019 before Mr. Staley filed for divorce? What was the balance in the USA account, which is 108?
The balance statement is $10,394.36.
All right, and then if you look at Exhibit 109, which is the same account, but it's ends in June, do you have that?
Yes, sir.
Now, it looks as if there was a total amount of 13,000 and some change that was taken out of the account. But if you look down at the other debits in May that went to the Schwab brokerage account from the joint savings or the joint checking account, did you make those transfers?
No,
All right. So that was made by your husband then, correct?
I'm sorry, Mr. Clark, could you repeat that? You cut out.
I'm sorry. And those deposits in Exhibit 109 to Schwab, they were made by your husband, correct?
yes,
Did he tell you that he was taking money out of the USAA account?
no, he never.
Okay. And then if you look at Exhibit 110, which is a statement period ending in July of 2019.
I'm sorry, 110?
110, yes, ma'am. Do you have it? Do you have it? Okay.
I don't have 110. Oh, I have it. It's underneath. Okay. Found it.
So you've got 110. This is that same joint checking account at USAA, Respondents Exhibit 110. And if you look at the back page of it, it looks like Mr. Staley wrote 3 checks out of the account that month. Is that correct?
Yes,
Okay. And so what was the opening balance of the joint checking account in June?
the statement or about the, okay,
Well, let me ask it this way. You see on the last page, check number 1487, Mr. Staley wrote a check to himself out of the joint account for $7,900. Do you see that?
yes,
And then after he finished writing checks out of this account, after he had filed for divorce, how much money did he leave in this account for you?
$245.75.
And when he made those transfers and left you with less than $300, did you know he was going to take that money?
Objection
No.
mischaracterizes the evidence that how much he left her as opposed to how much was left in that account.
I'll sustain the objection.
Oh,
Rephrase, please.
how much was left in that account for either you or him?
$245.75.
Okay. And then I will ask you to look at Respondents Exhibit 112.
Yes,
All right, so we previously looked at a check that your husband wrote for $7,900. In the Texas Trust account now, you see where that deposit was made?
yes,
Okay. And then look at Exhibit 113. You see that?
yes,
And so only 6 weeks after he filed for divorce. What's the balance that he had built up in his Texas trust?
$12,813.59 on the ending balance.
And did you know that he was moving that kind of money into an account that you had no access to?
I do not know of it.
And then finally on Respondents Exhibit 114, once again, is his Texas trust account. How much money had he stockpiled by that time, by August?
17,000, ending balance on August 31 is $17,488.31.
Okay. Now, do you agree with what he's told us previously, that all of this money he moved was community property?
Yes.
Okay. Let me ask you right quick.
I'm sorry, Mr. Clark, you cut out again.
Yeah, I'm sorry. Let me ask you to go back right quick to Exhibit 1, which is our request for relief.
I have it.
All right. We've already agreed to number 1. I think, tell us right quickly why you want Judge Hennigan to make you the primary parent that has a right to establish the residence.
Because I am always there for my children. I am their number one fan of when they get sick, when they're needed medical care. I'm the one that stay up with them when they're sick. When I go to the ER, I don't know where Mr. STAEHLE is.
How many times has that happened?
About two or three times.
Okay. Since your children have been born and in caring for your children, have you spent any time or spent any money on an extramarital affair?
None. No.
Have you been distracted by any other lover while you were raising your children?
No.
And he was engaging in this behavior before he left the house and before y'all had week on, week off, right?
Objection.
Yes.
I'm sorry, I didn't hear you, Mr.
That's
Pistol.
an objection, lady.
Sustained.
Did the behavior start before he filed for divorce or after?
I see the behavior change before.
Okay. You also have asked the judge to give you the exclusive right regarding educational decisions and invasive medical decisions and psychiatric and psychological decisions. Tell us briefly why you want the judge to do that.
Because I have a medical knowledge, I have a degree, I'm surrounded with medical people. I want to do more for my children. Education, I'm always been there for them from the beginning.
You understand what we're asking for is you would, of course, have to consult with Mr. STAEHLE before the decisions were made. You understand that?
Yes,
On possession and access, I think that's been explained. You're asking for Mr. STAEHLE to actually have an extended possession schedule. Is that right?
yes,
And the geographical restriction, it looks like you would be agreeable to the Arlington School District.
yes,
Okay. Standard holidays and then some summer vacation as is described in Respondents Exhibit 1. Is that what you're asking for?
yes.
Look at page 2 of that. Do your kids currently have passports?
Yes, but it's out of date. It needs to be,
Needs to be renewed?
yes,
Okay, and so you're asking the judge just to include the standard passport language, but you're asking that you hold the passports. Why would that be?
because I want to know what Mr. STAEHLE planned to do with the kids.
Okay, you understand that if he made plans and he told you about them, you would have to turn the passports over to Mr. Staley. Do you understand that?
Yes,
Okay. Now, I think the testimony is that you actually, with your job, have better health insurance than Mr. Staley has. Is that right?
yes.
So are you willing to carry the health insurance for your kids?
I can carry it until I retire.
Okay. So you're willing to do it once the judge grants your divorce and y'all go your separate ways. You're willing to carry health insurance for your children, correct?
Yes,
And how much does that cost?
407 as $407 as calculated current.
Okay, is that per month?
That's per month.
All right. And then you're asking that Mr. Staley reimburse you for the cost of your health insurance?
Yes,
I believe you're also asking that Mr. Staley pay guideline child support based on a salary of $94,000.
Based on, I'm sorry, Mr.
I'm sorry, gosh. We're also asking that Mr. Staley pay guideline child support based on his earnings of $94,000.
yes,
And you want and would agree to, if there's an expense that's not covered by medical insurance, that the parties would divide that expense half and half.
yes,
I forgot to ask you just minor, do you have a security clearance through the government?
yes.
How long have you had that?
Over 15 years
Okay, and why do you need a security clearance in your job?
to work in in my field in the Bureau of Prison.
Okay, and so they did a background check on you to get that?
Yes,
Okay. On community property assets, I think that's pretty self-explanatory. You're asking the judge to leave you in the house, is that right?
yes,
And based on our Exhibit 140, you're asking for that split because of fault in the marriage, constructive fraud, and waste of community assets.
yes,
And we've provided the judge some information regarding reconstituting the community if he finds or chooses or thinks he wants to do that in the divorce, right?
yes,
Okay. Are you okay with everybody keeping their cars and the property in their own possession right now?
yes,
And then in the supplemental inventory and appraisement that we provided, are you asking the judge to confirm as separate property what you have listed as separate property?
yes,
Okay. And then I think, to wrap it up, I think that I believe that Mr. Staley has been ordered to facilitate the return of your gun from his thing, and you'd like that to happen.
yes.
All right. Anything else? Your Honor, that's all I have right now. I pass the witness.
Mr. Pfister, any other questions?
I briefly have some cross-examination. Are we gonna, is the goal to just go, we're gonna work right through lunch and let's just finish?
Well, how much longer do you have here?
I probably got like maybe 15 minutes or less.
I would suggest you okay with this, Jennifer?
If we can take a break within the next maybe 15, 20 minutes, would be great. Just a quick break.
He's gonna finish in 15 or 20 minutes, he tells me.
Well, I expect to finish my cross, and then assuming that Mr. Clark doesn't ask any other questions or prompt recross, then the only other witnesses I foresee are the two attorneys on fees, and then we'd be done.
Those are about 2 minutes apiece, because y'all are gonna stipulate the qualifications, I presume.
So I think the entire trial can be done in less than 30 minutes.
You okay? You want to break now, Jennifer? You want,
That's fine, Judge.
that's fine. As in break now or go on?
No, that's fine. Let's just finish.
Okay. All right. Everybody else okay? Anybody need a break?
We're good here.
All right. Well,
We're good up here
if everybody's okay, then
in Denton County.
you may resume your cross-examination, sir.
Miss Staley, Do you remember I asked you in your deposition if whether or not you were withdrawing from those accounts that you claimed were your separate property, right?
Yes,
Do you remember us talking about it?
yes,
Do you remember that you said, did you actually withdraw from those to pay bills?
no,
Okay. Well, do you remember what your answer was to me in the deposition?
no.
All right. Well, let me help you out. I'm going to show you your deposition again. And Your Honor, I'm looking here at starting on page 55. I'm asking you what you're claiming as separate property. And you said, I'm checking USA Southside. And you said you opened them before marriage. Is that right? You remember this testimony?
I don't remember, but I'm saying, looking at it.
Okay. Well, you agreed with me. Okay, this was your sworn testimony back in February of 2020.
Yes,
And then I said, well, the money that exists there today is not the same money that was there before you were married. And you're saying, well, it's still there. And I said, well, let's start with the money in Southside. I said, isn't your paycheck going to that account? Yes, that's where. So you're saying your paycheck, does your paycheck go into that Southside checking account?
yes,
Okay. Does any of that work, do you transfer that over to your savings account?
no,
Okay. Now, then I said, what do you mean you exhaust your account? I said, how is this your separate property? And you said, because Mr. STAEHLE exhausted it. And I said, what do you mean? Because I'm the one that's paying for everything. He's paying for everything, means it's your separate. And then I talk about your USA money. And I said, are you claiming that? And I said, are you paying more than one before I met? And then I asked you right here, are saying that you reduced it. You've never withdrawn money or used it? And you remember, see your answer here on page 57, line 8? Yes, we withdrew and used it. So I said, during the course of your marriage, when you were married, did you withdraw the money from USA and then put new money back? And you said, we have withdrawn for bills. And then I asked if you've done any tracing. You hadn't, but so do you remember answering how you withdraw money from those accounts to pay bills? Does that refresh your memory?
at that time, I didn't understand your questions.
Oh. Do you understand them now?
Some of the money has been drawn from the account, but my money is still the same.
Okay. And you, now, each of these accounts earns interest, right?
Not very much. Yes,
Well, over the last 16 years, that's a lot of interest, wouldn't you say?
not what's been taken out.
Well, I thought you said you don't take money out.
Well, pay for the bills. Mr. STAEHLE has a bill. We pay for the traveling that we made. I pay all the traveling that we made in the past 14 years.
And so if you pay for it, do you think that you should be reimbursed for that travel expense?
Yes, I should be reimbursed for half of Mr. STAEHLE expense.
Okay. And so did you put new money back in the savings account to reimburse you from your paycheck?
Yes,
Okay. Now, ma'am, the mortgage every time, was it Mr. STAEHLE paying the mortgage?
not the past year.
Well, before you separated.
He paid the mortgage. Also, I paid for the rent when we were living on base.
Okay. Now, when I asked you earlier, one of your questions about, I said, why do you want to have primary? And you wanted to have more time with the kids. One of your answers I thought I heard was, you said you wanted to get to know your children.
Yes,
Right.
yes.
Do you not know them now?
I know them better. I just, Clarissa, she's turned 13. She has lots of questions on medical needs and lots of questions about females. And
Okay.
she wants more time with mom.
Okay. Now let's talk about, you said you're the one that addresses all their needs, right? Their educational needs. That's what I heard earlier.
All they need as needed. Yes, all they needs.
Isn't it Mr. Staley who went and had him diagnosed with Ethan with ADHD?
Yes, he make a suggestion.
Right. And you fought him on this. You resisted this. Because you didn't think he was right.
First of all, the same doctor diagnosed
Action
Ethan.
non-responsive.
Staying.
Yeah, ma'am, you can go back and explain later, but the emails, the text messages, you were arguing with Mr. Staley about whether or not Ethan had an ADHD problem, right?
Correct.
You didn't even go to the doctor's appointment where he was tested.
I was not notified that day that he has an appointment.
So the short answer is no, you didn't go.
No, I did not know.
Okay. Now, do you take the children to their activities?
Yes.
Okay.
And no.
No. In fact, do you remember we had a discussion about this in your deposition? I asked, would you take them to activities if Mr. Staley signed them up?
It depends on my weeks.
It depends on whether or not you have anything to do, right? You remember that?
I said it depends on his week and my week.
I said, will you support the children?
Yes, I do.
I said, will you take them? Look at this. Do you support the children going to these activities? And you said, I'll take them when it's your week. I said, my week when I scheduled them.
Yes.
So when are they? I said, what if Mr. Staley signs up?
Well, Mr. Staley take him to his week.
Okay. So if Mr. Staley signs your son up for an activity and the activity is on your week, are you going to take your son or daughter to their activities?
I have been taking Clarissa to activity as far as my schedule week, as co-parenting, that the children with that person should have more time to spend with their kids.
Let me interrupt you. I'll just tell you that for extracurricular activities, each of you will be required to take the children to their activities, whether it's games, practices, recitals, whether it's your week or not your week. Most likely, I'm going to order that y'all share the choice of extracurricular activities to where, for instance, Mr. Staley, you may have the right to choose during the fall semester of the school year. Ms. Staley, you may have the right to choose during the spring semester of the school year, and then likely it will probably be reversed the following year. I don't want to overload these kids, but the kids need to go to the activities, particularly if they start participating in team sports, like Mr. Staley says he's interested in putting Ethan in soccer. But nevertheless, whether it's horseback riding, martial arts, tennis, soccer, baseball, whatever it is, the kids need to go regardless of whose week it is. So okay. I'm just going to tell you that's going to be part of the order. And we're not going to have this where each of you take the children when you have possession of them, because it's not fair to the kids for them to be in an activity and not be allowed to go. So I'm sorry, Mr. Pfister, but
yes, I agree with you, Judge.
Well, that's not what you told me during your deposition, is it? You didn't want to take him, you said, if Mr. Staley signed him up.
Because I don't want to over my children. If Mr. Staley has martial art and I have him in swimming, and that's overloading my son, that is why I did not take him to Mr. Staley's week, because I have Ethan sign up on my week for something else.
Hey, ma'am, I understand that's your answer now, but that wasn't your answer back in February of 2020, was it?
I think the judge has made it very clear.
I'm just trying to go to show the judge when I said you were opposed to taking it in martial arts, it says, if I have no other plans for it.
Well,
And
Judge laid
I'm
down
going
the
to
law.
object, I'm going to object to sidebar comments outside of his time to cross-examine it or direct his own.
Your Honor, I object. This is irrelevant. You've told us how it's going to be, and you heard my client say on the record she agreed.
I heard what she said, Mr. Pfister, in response to your question. I heard what she said in response to my little sermon there. And so let's move on, please.
All right, I will stop there. I have no further questions.
Just one right quick. Now, Ms. Staley, did you go to the doctor's office when the diagnosis of ADHD was made?
Yes, I did.
Okay, and both you and Mr. Staley were there?
Yes.
And just who's the doctor that made the diagnosis?
Dr. Tamron Hayward.
And had Dr. Hayward made any other diagnosis of Ethan previously?
He was diagnosed with asthma.
Okay, that's all I have, Your Honor.
Mr. Pfister, any other questions?
No, sir.
All right, I just have one of you, the same I ask of Mr. Staley. Are you currently involved in any bankruptcy proceedings? Ma'am?
Me? No, sir.
No.
No.
And I'll ask you another question, just to get straight from you. You're not expecting a child at this time, is that correct?
No.
All right, thank you. All right, Mr. Pfister, call your next witness, please.
Myself?
All right, and as I understand, you all stipulated to each other's qualifications, correct, Mr. Clark?
Yes, sir.
All right. So what I would need from you, Mr. Pfister, would be just your bottom lines, and if you have an exhibit, certainly offer it.
I do. Your Honor, my exhibit is Exhibit 61. My bottom line, as of probably the close of business today, is going to be just over $40,000 to represent Mr. Staley in the course of this divorce proceedings. I believe that is a fair and reasonable charge for someone of my experience. And I guess I didn't lay the predicate that, I've been doing this for 28 years and I'm board certified.
He's stipulated to your qualifications.
But so I believe that's a fair and reasonable fee to represent someone in this throughout this and all the discovery and the 2 mediations we've done and now this day and a half TBC.
All right, thank you. You pass yourself as a witness, sir.
Yes, sir.
Mr. Clark, do you have any questions, Mr. Pfister?
No, sir.
All right. You have no other witnesses, correct, Mr. Pfister?
No, sir.
Would you rest?
Yes, sir.
Mr. Clark, do you have any other witnesses?
Just myself on attorney's fees, Your Honor.
And Mr. Pfister, again, you will stipulate to his qualifications, correct?
Yes, sir.
All right. Bottom lines, please, Mr. Clark.
Yes, Your Honor. The bottom line on through the end of the trial today would be $29,956.90. I'll also just mention to the court that Ms. Peterchuk and I both worked on the case, but that doesn't mean we were both billing on it. I believe that amount of money is reasonable and necessary to defense and of this type of case. And that's all I have.
Pass yourself.
Yes, sir.
Mr. Pfister, you have any questions, Mr. Clark?
No, sir.
All right. Any other witnesses, Mr. Clark?
No, sir.
Do you rest?
Yes, sir.
Mr. Pfister, you rest and close?
Yes, sir.
Rest and close, Mr. Clark?
Yes, sir.
All right. Mr. Pfister, did you have any final argument that you'd like to make at this time?
I would like to make some closing arguments. You've heard from the parties, but you also heard from 3 objective educational witnesses. I think those witnesses clearly showed who was looking out for the educational interests of the children. I think when you sit down and you listen to or review the testimony from both parties and all of the evidence that has been presented in the last 2 days, that Mr. Staley should be appointed as the person with the right to determine the primary residence of the children. I am asking that right essentially is going to be limited because whose primary is really not going to have a huge difference. because I'm asking for an Arlington ISD domicile, which apparently now they're finally agreeing to. I'm asking, and Mr. Staley has offered to do offsetting child support. So even though he would be primary, there's nothing that prohibits him from being ordered to pay child support in the 50-50 arrangement. Mrs. Staley seems to want to go for broke and say that the loser gets a standard possession order. Now, Mr. Staley had already testified he didn't think that was appropriate for the children, that they both need both parents. And given that they've already been doing week on, week off for a year, that we ought to remain in that capacity. The only thing that we ask that to modify from the current temporary orders is we need to add some kind of summer provision. And that's why I suggested a 14-day and 14-day on off for designation. I suggest that the court adopt standard holidays as set forth in the Texas Family Code. And if you'll recall, Mr. Staley said he wanted the Thanksgiving holiday. So that would mean he gets the Thanksgiving in the back half this year, and next year, so mom will get Christmas this year, and then next year they would flip. The only other modification was to modify the exchange from Friday to Sunday, because logistically it does make more sense to drop them off Sunday at 6 p.m. as opposed to trying to do it Friday at 6 p.m. when the parties are, there's a lot of traffic. Now, we get into their reasons for wanting, why they want primary, and I just didn't hear any valid, real reasons as to why you should change from what is the current status quo, or even why she should have primary. There's just no objective evidence that was produced by her that would address that. On the financial side, I understand she produced some accounts that showed what money she may have had on the week before marriage or 2 months before marriage in one account, but there is a wholesale failure to trace those accounts that would come anywhere close to what would be sustainable to prove by clear and convincing evidence that these funds that exist today are traced back to those funds and thus are separate property. When you look, for example, at the TSAP, she has no valid explanation as to, other than she said market forces. However, I would ask you to look at their own exhibit. And one of the things I noticed is in the exhibit that they introduced in their TSAP that showed the account before marriage. If you look at in the bottom of that exhibit, it shows the distribution of the money. 100% of it was placed in government securities. None of it was placed in stocks. Government securities are government bonds. You do not lose a dime in government securities. And so then you compare that to the exhibit we produced, which showed that $100 and some thousand was produced over the lifetime. And that alone destroys any credibility that the 31,000 that was traced over to is separate property at this point, because clearly there had to have been some withdrawals. At the very least, they have failed to meet their burden by clear and convincing evidence showing that those accounts. Then you go to some of these savings accounts that they're showing, and again, we have a wholesale failure to trace the funds. They did produce the accounts from going forward from the day of marriage to today to show that the balances never went down. And then if you'll recall, Mrs. Staley in that last question where I said you withdrew from those accounts to pay bills, and she acknowledged she did. And then when she was saying, well, she needed to get reimbursed for vacations or whatever. Again, I understand that there may have been some money in separate property, but there still is a failure to trace it. One of the reasons I introduced evidence to try to show that Mr. Staley also had some separate funds is that the court knows that, yes, we had separate funds as well that we didn't trace or that we didn't try to trace. And so the bottom line is, I think based on the record of what was presented in court the last 2 days, that the court should treat all of the assets of the parties, with the exceptions of personal property items, as community property and divide the estate in a fairly just and right manner. That's going to be close to Exhibit 20B that we introduced. The only thing that I would modify from that is, yes, that we concede that the separate property home is her separate property. What I would propose, if the court wanted to modify that, is to split, for example, the savings account 6884 or one of those other accounts, so that we could go. Now, we took these numbers based on the assumption of what they were saying. I find it interesting that a lot of these numbers have gone down from the documentation that we used to have. Now let's address some of their waste claims. We conceded the 88 or the 80 some $100 that she spent. There is no evidence of any amount over and above that would constitute a waste claim. The money spent, transferred before marriage that they're asking for, the 10.7, their own documentation shows he transferred it to another account. He transferred community assets from one account to another account. All of that money was accounted for because we produced the bank records from Texas Trust that showed. So there's no waste claim there just because he transferred the money. And I understand that they're trying to garner sympathy by saying he only left $200 and some. He may have left $200 and some in that one account, but keep in mind, she's got tens of thousands of dollars in her Southside and USA accounts at the same time. And he knew that. Then you go through the other thing, restitution of the Lockheed Martin 401k. That is whether or not his participating in exercising the stock market and playing the stock market is a waste claim. Now, while these decisions, and you and I can sit back and in retrospect, that was a bad decision, and that was probably foolish on his part to do, that does not constitute waste as defined in the Texas Family Code or the common law of Texas. That is not like he went up to the casinos and dropped that money down. It's playing the stock market. And while, again, you can second guess, he did it over years. And yes, he lost money. Of course, the stock market also crashed during the COVID thing. The reconstituted sale, he explained that they didn't pay that tax. He got that notice. And then he said, I called the IRS and I fixed it. There was no evidence to show that he in any way received $43,000 from Pfizer. And also keep in mind that the tax statement that they keep referencing and they tried to reference in their exhibit was never introduced in evidence. The national envelope 401k, again, there's no evidence to justify, I mean, it's only $880. Then you look at reimbursement for the claim, $30,000, community property went to community estate. Again, that's not something that is reimbursable now at the time of divorce. And the same thing with the $8,000. There's no evidence, I didn't see any evidence of wife's separate property reimbursement claim for the marital residence that they're asking for in the request to relief. No documentation, no checks, no evidence, not even testimony, nothing that would support that. So there's nothing in the record that would support all that. And so at the end of the day, I'm asking the court to grant something closer to what's in our 20B. As far as the marital home goes, even if the court were to adopt their numbers, you're looking at a community asset, clearly it's community, and you're looking at a community asset, according to their own numbers, of somewhere in the $92,600 range. The bottom line is if you give the wife a $92,000 asset and you put it into the spreadsheet here at 20B, I'm not sure what you're going to transfer over. I guess we could take, there's some of the cash or more IRAs that you could transfer over. But it would seem to me that it would probably be better to just sell it if wife wants to buy it. Then we look what the market is. And I mean, she can be the buyer if she wants to buy it. If the House court is going to award it to her, then we ask that the court, any equity that's being awarded to her or to Mr. STAEHLE is going to be with an OLT lien onto the house. and with the court providing a deadline for her to refinance the house and pay the OLT amount that the court awards to him. And at the same time, the court should put, in the event that she does not do that, that then a receiver would be appointed to sell the house and divide the proceeds the way the court had decided. So for example, the court, even if the court wanted to adopt their proposal of $20,000 or $30,000, then give her a time certain to refinance, pay him that amount, that 20,000 or 30,000 or whatever number you decide would be an OLT lien on the house. I think that all of that would be a fair and just division of the marital estate. And I think that our requested relief regarding the children is in their best interest. Thank you.
Thank you, Mr. Pfister. Mr. Clark?
Yes, Your Honor. I think that as you evaluate your decision in this case, I think that Mr. STAEHLE's credibility is at the heart of your decision. You've got a fella who thinks it's good parental judgment not only to have an affair, but to drag his kids to meet his lover. You've got a father who thinks it's good a parental decision to take his young son, who he's so worried about his behavior and his ADHD. He takes his young son twice to see how he's going to behave around his girlfriend. You have a father who wants a lot of cash in his proposed division of the estate. And it seems as if probably the only reason he didn't lose more money is because he couldn't get his hands on the money. Now, when we look at his trading and he keeps doing it, I think that is a profound lack of judgment on raising kids and on finances. When we look at the decision to be made, we heard the educator, and Mr. STAEHLE finally admitted that the medication problem was 2 instances and 2 instances only. The other thing that he brought to the court was he said that the children were left alone on 1 instance that he knew of. You remember, Judge, time and time and time again, he was impeached with his deposition regarding the down payment of the house. He gave us passwords in the deposition under oath, and then he changed them so she couldn't look at the community property accounts. This is the character of Jim STAEHLE, and that cannot be ignored. So I would argue that we leave mom primary. The proposed relief we asked for would give Mr. STAEHLE expanded possession and access. We need Mr. STAEHLE to reimburse for the health insurance and let the kids stay with their mother in the house where they were raised. Regarding the money aspect of it, I think if you look at the proposal we have, which is Exhibit 140, I think it lays out.
Exhibit which, I'm sorry, Mr. Clark.
140. I think it lays out in a very fair terms what would happen if the court decided to reconstitute the entire state. Now, I do obviously, Judge Hennigan, of course you can do anything you want to do, but I think that would be what we've asked for, would be basically 100% reconstitution of the community estate. I think that if you keep it week on, week off, I cannot imagine, and do the exchanges on Sundays, I cannot imagine the horrible traffic jams that must occur within the Arlington Independent School District that gives either of these parents reason to go against what the Texas Family Code provides, other than he's got a girlfriend. I don't think, given his character, I don't think given his credibility, I don't think given his poor parenting judgment, I don't think given his poor financial judgment, that he should be in a position to be the primary person to designate the residence, nor should he have those educational decisions or medical decisions. You would have to ignore a lot of his behavior to keep the situation the same as it is right now. And other than that, I would just rely on our proposals that we gave you, and I thank you for your time, Your Honor.
Thank you, Mr. Clark. All right, I will grant the divorce. And I will talk to Clarissa. The only way that I know to talk to Clarissa or to any child in today's time is to have that child go to one of the lawyer's offices and have the child with the promise from the lawyer that the child will be placed in a room by herself and be set up for a Zoom conference with me. We don't have any children down in the courthouse now. And so my suggestion would be that maybe Mr. Clark's in Fort Worth at least, and I know you're in Plano. I think Mr. Clark's a little closer, or a lot closer. So I would suggest we do it over there, and I would trust Mr. Clark to make sure that the child was not being influenced in any way, and no one else would be in the room with her as she was talking to me.
Absolutely, Your Honor. No,
And I would also trust that whoever brought the child to Mr. Clark's office would, that neither of you would be in any way trying to influence the child in any way as to what she should say to me in our conversation. So, Mr. Pfister, can you agree that the child will go to Mr. Clark's office and be set up for a Zoom conference there?
I was going to ask, Judge, if in order to balance out the equities, can Mr. STAEHLE be the one that brings the child to Mr. Clark's office?
What kind of equities would be balanced out by that?
Well, that way, at least, I guess he can sit there and he can sit in the lobby and see that she's in a conference room by herself.
I'm sure he has other doors going in there. If I didn't, both of y'all are officers of the court, and I've known Mr. Clark for a good long while. I would trust him as I would trust you, sir. And I think if a lawyer tells me that he or she is going to honor my request and do what's right.
I will honor your decision. And I was looking at it not from my perspective. I was looking at it from the client's perspective.
I don't really care I honestly don't care who brings the child. Who has the child right now?
I do.
Okay. My suggestion, let's just do it this afternoon.
Okay.
yes, sir.
Yes.
And we'll get that out of the way.
What time, Your Honor?
Well, you're at home. Are you at home now, ma'am?
No,
No.
she's in our office downstairs.
Okay. So you have to go back home and get her. Is she at home?
Yes.
Does she have anything this afternoon?
She have nothing at all.
Okay. I would rather get this out of the way. Mr. STAEHLE, I hope you understand this is not anything that I'm trying to have her influence in favor of mom at all.
Yes.
But I'd like to get it done. And this afternoon's a good time because I had y'all scheduled for all day today and tomorrow, and really for the next week, I'm going to be pretty busy. How about at 2:30?
We're certainly available anytime. Ms.
That's plenty of time.
Okay, well then I will try to get another Zoom invitation out to Mr. Clark's office at 2:30. And again, Mr. Clark, you put her in a room by herself and make sure she's set up with a Zoom. And
Yeah, I'll have my paralegal set it up. She's our technological person, and then we have a door we can close and you can do your conference, Your Honor.
Yeah, and I have no problem with your paralegal going in with her in the beginning to make sure the Zoom's working,
Yeah, volume and all that stuff.
and the paralegal leaves.
Let me mention one thing while we're still kind of on the record. Ms. Peterchuk is going to burn down my office unless I cite one case to the court. And it's a case of Puntarelli versus Peterson. And it discusses the reconstitution of waste in an estate when a spouse doesn't know what's been going on. It's 405 Southwest 3rd, 131. And it's a 405 Southwest 3rd, 131. It's a 2013 case out of the first district in Houston.
What's the name of the petitioner in that case?
Puntarelli, Puntarelli versus Peterson. Now, hopefully I can keep a valued employee.
Well, I have no problem. If you would like to email me that case, you email it to Mr. Pfister as well.
Sure. Yes, sir. We'll do that right away.
And Mr. Pfister, if you have any that you want to send to me, you're welcome to send it as well. All right, I will talk to Carissa, and then I will send a rendition out to the two lawyers here, hopefully pretty soon. Jennifer is going to be out about 3 days next week, and so it may be the following week, but we'll get it out to you hopefully by then. So the only thing I would hope is that the two of you can set aside y'all's differences as much as possible in an effort to co-parent these children. And I think right now that's probably a little bit difficult for the two of you. But I think it's important, obviously, that these children have two parents who can cooperate with each other and who will not disparage each other to the children, and who will make themselves available as backups for each other, and just take care of these kids, because Carissa's at a vulnerable age, as is Ethan. And so you need to work together, even though y'all are not married anymore, even though you don't particularly like each other right now. At least in front of the kids, be cordial and cooperative. So I hope y'all can do that. And I will tell you that one of the things I'm going to order is that there's a group here at the courthouse called New Day Services. I'm going to order that you both take a parenting class, an Access Without Conflicts is what it's called. It's a co-parenting class. And then also each of you will take what they call focus classes, one for fathers, one for mothers. And those will be ordered. And hopefully that will help y'all get by some of this and get on with raising your kids. But I'll put that in the rendition and send you the phone number. If y'all are here, I'd give you the brochures, but you're not. Anything else, Mr. Pfister?
No, sir.
Mr. Clark?
No, Your Honor.
Both of your attorneys did great jobs. They're really good attorneys, and y'all can be proud of them. They represented you well. So good luck to all of you, and all of you stay healthy. Thank you very much.
Thank you very much, Judge Hennigan.
Thank you.
Thank you, Ms. Hudson.
Thank you.
Sir, it's Hunter, sir.
Hunter. She's going to kill me next time I see her, which might be in 2023.
Better wait, because she's not the singer.
I know, and she knows I'm scared of her anyway, so I really don't.
Yeah, right.
Myself.
Y'all be careful.
Thank y'all very much.